May I please, Your Lordship?
Yes.
Lordship, I beg to mention for listing of one IA, Lordship.
Ah.
Suspension of sentence, Lordship.
When?
After Diwali vacation, Lordship. Any date, Lordship.
Give a date. Write a date. Give it to
Lordship. Give your Lordship.
I seek a lordship's indulgence in making a mention.
Yes.
Your lordship, item 3 of today's hearing list.
Yes.
My lord, I have received the paper book just yesterday evening.
Okay.
Haven't had the time to prepare myself, so if the matter can come up some other day, my lord.
Okay. So we adjourn the matter.
Right.
Uh,
A date to be fixed, right?
huh?
A date to be fixed.
Right. Okay. The PP Mizoram
Yes.
has made a prayer for adjournment on the ground that she had received a copy of the paper book only yesterday. The same not being objected by the counsel for the FLN. Leaves the matter after 4 weeks. You were date. 21st November.
21st, my.
All right.
Maybe on 20 November, my lord. It's a hearing date, 20.
20 November.
20.
Indian November. All right. Obliged.
Obliged.
Lordship, in this matter, personal appearance of the OC Jalopari PS was called for. As usual, they have not served copy on the other side in spite of several endeavors made by us. My lord, today also, Lordship not turning up.
We'll direct the DGP to ensure that he appears. What to- Right. Mr.
V.A. Chaudhary, Lordship.
V.A. Chowdhury
No.
appears for the appellant. While Ms. B. Buyan, learned additional people, appears for the
Respondents to.
state. The matter, the present app- has been filed against the when dated 5/7/2022, passed by the Court of the Special Judge Pokso, Kamrup M. Guwahati, in sessions case number 401/2018, arising out of Jalukbari PS case number 1159 of 2018, by which the appellant had been convicted under section, convicted and sentenced under section 4 of the POCSO Act. First up. Next paragraph. This while admitting the appeal on 26/8/2020, had directed the counsel for the petitioner to take steps for service of notice upon the informant slash respondent number. Thereafter, White order dated 5/5/2025. This court directed the learned counsel for the appellant to take fresh steps to be routed through the office of the learned PPSM for service of notice upon the respondent number 2. As the conviction and sentence involved the POCSO Act. Next para. The perusal of the subsequent orders passed by this court shows that the learned PPSM, the learned APPSM was to obtain the status report from the officer of the concerned police station, officer in charge of the concerned police station, as to whether notice had been furnished to the respondent number 2. Next para. In the order dated 19/9/2025, passed by the submission made by an additional PP had been recorded where the learned APP had submitted that despite seeking information from the OC, Jalukbari PS, with regard to whether notice had been served upon the respondent number 2, no communication had been made by the concerned OC. First, as no communication had been made by the OC of the Jalukbari police station, this court had by the above order dated 19/9/2020 directed him to appear in person on 16/10/2025, to explain as to whether notice had been served upon the respondent number 2. Unfortunately, the OC of the Jalukbari police station has not appeared in this court, despite the order dated 19/9/20. Next part. A perusal of the above orders shows that the that no implies that no steps have been taken by the OC of the Jalukbari police station to serve notice upon the respondent, and that he has not not, and besides that he has not entered appearance in compliance with the order of this. Next. We are of the view that the matter needs to be taken seriously by the police authorities, in as much as the orders of this court have been flouted, appears to have been flouted intentionally, without any reasons being provided for the same. Next up, Ms. B. Buyan, additional PP submits that he has not been given any intimation, any communication by the OC of the Jalukbari police station with regard to service of notice upon the respondent number 2. With regard to service of notice that had to be effected on the respondent number 2 by the OC of the Jalukbari police. Next up. In view of the reasons stated above, we request the Director General of Police, Assam, to ensure that the OC Jalukbari Police Station and personally appears before this court on the next day. I want to explain as to whether notice has been served upon the respondent number 2. If not served, the reason for the same should be given by the OC of the concerned police station. List the matter on. Give a date.
2/8.
It's too short, na? Even I will not do. I'll give the week before that. 5th. Or 5th, 6th. 6th, next para. A copy of this order be given to the learned additional PP Ms. B. Buya for communicating the same to the DGP Assam.
Can it go through the
First
ASP
up.
also?
Besides the above, the registry shall also serve a copy of this order to the DGP Assam for compliance.
Lordship, can it be observed? The order dated 99 was duly communicated on 29/2025.
Where Ms. Buyan, we have talked about Ms. Buyan, no? You said that
Officers communicated, Your Lordship.
also submit that the order dated 19/9/2025 had been duly
Communicated by the Office of the Public Prosecutor
communicated by the Office of the PP
on
High Court on
29/2025,
29,
2025.
no, 29, 2009,
Yes,
2009,
yes, my lord.
2025.
As also yesterday also,
To the OC, to the OC Jalukbari Police Station.
and also yesterday, my lord. It was
The order was again communicated yesterday. That is
15/9.
10.
And our
20
PP has also talked over phone, informed over phone.
Further, the additional PP submits that the learned PP had spoken on phone
Yesterday,
on 15/10/2025
15/9. Oh, 15, I'm also sorry. 15/10.
to the OC of the Jalukbari Police Station with regard to the order dated 19/9/2025. If he doesn't come next time, so moto will take up temporary. DP obliged.
Your side. I always, before I start, I look other side also, my lord. That's the whole problem. We start, other side will come, wasting all time of the court. I think twice this matter was listed and some time was taken. I made a note of it, a very short note. I think, as per my opinion this is a case where your lordship can consider for a bail and sentence also to be in view of the judgment of the Supreme Court and also under the statute. Very clear. Because I am already in custody. I was granted for how many months? 82 months I am in custody. So by virtue of the provision of the statute, I am entitled. Half the term,
I don't which statute?
Statute, there are two statutes. I will show under the old CRPC 436A and under the new BNSS.
Oh, that is for UTP,
No,
convict.
I will show a judgment that it is also equally applicable to convict also. There is a judgment of the Supreme Court. Our High Court is a division bench say that it is also applicable to convict. That is what I am showing you. I know that will be a question to be, your lordship will ask me. And based on Satyendra Kumar Antil judgment, Supreme Court judgment, based on that judgment, our High Court division bench says that it is applicable to convict also, not to UTP. Because the provision under 436A was half term. So he was granted bail by this court when he completed half term. Thereafter, when the judgment was passed, he was convicted, then again he went inside. So he is there inside as on date. Now, I have not come across with great respect of the learned trial court where the sentence was consecutively 31 years. Rest, I will show how selectively it was done, equally on equal footing other members, 10 years, because it is a PC Act. Concurrent. Always it will be a concurrent. There are judgments. I am equipped with all the judgments of Supreme Court. It is always has to be concurrent, not consecutively. Now, the learned trial court cannot, because
Is there a bar if consecutive sentences?
there is, but he could not, because 31 years consecutive, he knows that only I can do 14 years. Maximum is 14 years.
That is if there is remission.
No, not remission. Not remission under the statute. Section 31(2). It is a bar. which you cannot. That's why 14 years. 31 consecutive, the learned trial court knows that there is a bar, even 31 years consecutive, but only maximum which I can do is only 14 years. Now, if 14 years is to be taken into account, then my lord, half the term in 7 years, 84 months. Now 2 months is left, but by virtue of the provision,
So you wait for another 2 months.
no, on 479 I'm entitled, my lord. That's why I'm saying under BNSS.
For the other side,
Well, always that's the problem, my lord. Your lordship knows, that's why I wanted starting of the case. Not once, twice. So we'll wait for them if it is not inconvenient to your lordship, ma'am. I am, my lord, my basic argument will be under 1/3 rule. Because 56 months, one third of because of 479 of BNSS, where you get a benefit because being a beneficial legislation, you get a benefit of retrospective effect if you are a first offender. Otherwise, you will not get first offender. So, my lord, my term already is over. 56 months. And today, 82 months. 82 months I am in custody.
that is one side of the coin.
No, you, my lord, I placed it before the other side has to give a reply. And I have to show it. It's only I have to show it. Your lordship have to be satisfied.
So let us wait.
Yes, wait for it. Time? Oh, your lordship,
Huh?
is there other matters, my lord, for Passover? There are few matters, I think.
There are few matters.
matters.
I'm saying because the other side is not here, no point hearing you.
I don't want. That's
Ah.
why I just place it
Hmm.
before this court because not once, this is twice, thrice. That's what.
If he comes, we'll do it.
PP Assam's name is shown. The policy is minor PP Assam.
Special, maybe, no.
Special PP.
PP Assam has been shown.
Yes. it is. So, Rakesh Kumar Paul.
Last time he was president.
Order was given in his favor.
16 was fixed in his presence, but
Maybe.
maybe.
Everyone forgets. Everyone doesn't have a computer mind like you. Or your juniors.
I don't believe in computer manner. I believe only in statute because I am very old type person.
That's what-
I'm an old type person which I don't see laptop. I have no computers.
No, what we are trying to say is that what has happened 2 days ago, we don't remember. So this PP also might not remember
Your-
just because he was there. on that
Your
day.
lordship is loaded with so many cases. We are only few of cases we are loaded.
We
How
are
many
very
cases?
busy. From here, you'll be taking a 100-meter sprint to some other.
No, I'll not. Well, let it to, because what my learned friend says that PP Assam has been sold. Maybe he may, so your lordship can indicate that a particular date.
It depends upon you. You want to wait, we can wait. You
I
want to
will wait.
adjourn, whatever. We all decide.
But Passover timing, let it go.
Lordship, our matter was there. The Lordship heard the oral dying declaration.
That matter, thing matter. Yes, Miss S. Sharma was there. Yeah. She's gone out.
I'll just take.
I think we are in a partner. We are having a partner matter.
My lord,
That we can do your matter.
my lord, in that case, my lord, item 4, it pertains to section 302, my lord.
No.
And the 1 point is insanity. So,
And-
my lord, can it be taken up just after the?
The eyewitness also.
I'm not on the fact, my lord. The person has killed his mother, but the fact is, my lord, he's responsible.
Say no.
He's responsible for the death, but he may not be liable for the death. My lord. That's the only ground. Because liability is not there. Section 84 comes into play, my lord.
So that was there any test done?
Nothing, my lord. He was 3 months.
Did you take the plea at that time?
Yes, the plea was taken, my lords, but the learned court below had brushed aside the
Did you produce any document?
no documents, my lord. But my lords, there are judgments, my lords, which says, my lords, the attending circumstances have to be looked into. Well, this person killed his own mother without any reason, then he slit his own throat.
And he admitted in 313.
He admitted he slit his own throat, and when question was posed to him,
Not slitting about the death. I
About the death,
say
yes.
about the slit.
I'm not on that. He killed his mother. That is my lord.
He killed his mother.
No, there's no motive, my lord. From the
There
evidence,
is not, Lordship is aware of in eyewitnesses account, motive is not a crucial factor.
I'll satisfy your my lord, kindly after the.
No, but he basically says that he was. Let's hear this first.
My lord.
First he's here. Then after that, no, we'll hear this. We'll hear your case today itself.
Today, my lord.
Today itself.
I require some further preparation, my lord.
Hey, what preparation?
Okay, my lord.
We'll
I'll start. I'll start.
He basically said the entire case. Nothing remains.
My lord.
After 11th. After 11th.
Yes, ma'am.
Okay. So, yes, both of you.
Yes. Lordship, she wants to continue on.
She can.
I will try to satisfy your lordship only on 2 points.
Ah,
That quarrel thing which your lordship had put in query on the last date, as well as the common intention. Because common intention would be very.
You finish off your part. Why you wait for?
Yes, I will.
Ah.
So
Quarrel.
quarrel,
Number 2 is common intention.
yes, quarrel, I concede your lordship. Your lordship was correct on the last occasion to say there are 2 Supreme Court judgment, which I pass on, which says blows are necessary. And the other example which your lordship has put, then when a person sees his wife in a compromising position, that itself is also an provocation. So that point, I'll leave it on that. Only the clarification that blows, quarrel and blows, 2 Supreme Court judgment it says, for exception 4. So that part I will not insist on much regarding the common intention. Because
So yeah, basically you're restricting your arguments to common intention.
apart from the arguments that I have done on the last occasion.
Naturally, no. So common intention.
Common-
basically.
Because your lordship, they have not been able to prove which person stabbed. And the finger, they have not done a
But
finger
then
test.
both of you have blamed each other.
Yes, if the common intention.
Yes. Witnesses and
For
deposed.
PW4
Yes,
has said that Ms. Sharma's client has done it.
yes.
The Ms. Sharma's no
PwC.
PW6 has said that
Nippon reply.
you have said that he has done it.
Yes.
So which
Blame
one?
game on each other.
Blame you.
Blame them, but if the common intention is not being proved.
So common. How do you prove a common
Yes,
intention?
I
when,
will come on that only, lordship, only on that. Your lordship, common intention, one, if it is pre-arranged, is not a problem, you can know from the conduct. But here it is from the spur of the moment. Your lordship.
Can common intention spring up at the spur of the moment?
Yes.
Judgments.
Yes, it can,
Then
but then the prosecution will have to prove and lead evidence regarding to the fact. of
no, but
common-
then supposing no one is there to see it, then
From
what do you do?
Then from the conduct and the circumstances and the evidence that has been established. So we'll have to see on that part. Your lordship now. Here, and mayor present itself also, it goes both way, does not prove common intention. Mayor presence, like the mayor presence of,
Present.
mayor presence of a person with the co-accused at the place of occurrence does not by itself prove common intention unless there is community of design. That has to be proved by the prosecution. Now, in this case, your lordship, both the accused are brothers. So their being together does not give any inference that they had the design to be at the place of occurrence to commit that crime.
They are brothers.
They are brothers. So that does not give any inference. Inference, they're being together at the place of occurrence or being,
They were seen running away.
no, they were not seen running away. They were
seen running
captured.
away.
They were
They were
captured. So that there is a evidence, they were captured.
No. You
And-
come to PW1
And also running away does not,
later on. Running away, even if you run 5 steps, that means running away.
running away also, your lordship, there is a Supreme Court judgment I'll show, which does not give the inference. Because this is a natural act. If a person commits a crime, it's a natural act.
You see out here,
Yes.
Benukar says a Putu Pulin who accompanied me flashed the torch he carried with him. The accused fled from the place of offence.
Page 16.
Page 10 also it is there. Page 16 is again, when I flashed the torchlight, I saw the accused person fleeing away. So fleeing away,
Fleeing away by itself will not do, your lordship, let's come from first step first. First, my argument is they're being together by itself because they are brothers. So that would not give an inference. They had a motive or pre-arranged plan to commit the crime. Second most important in the evidence that has come out or the conduct is that the meeting of the with the disease was accidental.
that is right. That is right.
Accidental.
Initially there was nothing, no
Exactly.
problem. Because he said that you all are drunk, go home, don't cause nuisance on the streets.
And also there is no evidence to the fact that they knew from before that the disease would take that path. So these are also important.
No, that is all right. But then you see,
And second was, your lordship, just
yeah.
the 3 points I have is that there are the injuries and the weapon use. There is only one weapon use,
correct?
one weapon and 2 injuries.
Yes,
And
correct.
both the injuries are by knife,
Correct.
right? And so the other person has not taken active or covert part because there's
Which person?
which person the prosecution has to establish the which person has stabbed it. They have failed to establish that. Now what I'm on,
In that case, it is your duty to say the truth.
now which truth to believe? I have said that I have not done. Though it's a hearsay evidence, I have done my part. What I am on, your lordship, injury is the nature of the injury and the weapon use is very important because they are no other bodily injuries. Of injuries that can possible by fist or by not by other weapons also, but there are no evidence to that effect. So one person has done covert act. The other person, there's no evidence to say the other person has instigated.
We don't know.
Provoke.
They might have both held the knife
They
together
might have.
and
They might have.
we don't know.
Yes, we don't know. They might have, or other person might not have also instigated, because that is important. If he has not taken part in instigating, because that has, at that moment, the common intention has to be derived from. Because there was no intention to kill that person prior to that. In that regard, only 3 short judgment, very short. Because there has to be evidence to the effect that the other accused has done some covert act or instigating.
Yes.
Paragraph 10, Your Lordship.
Which are Rangaswamy.
Yes. 1989, Supply 1 SCC 636. Come on, reading those. Paragraph 10, Your Lordship. We have given the matter a careful consideration and we find considerable force in the contention of Mr. Suenso, while the evidence and record clearly establishes the presence of A3 along with A1 and A2 at the scene of occurrence. The evidence is certainly not adequate to hold that A3 has shared a common intention with A1 and A2 in the commission of the offense by them against Jairam and PW1, respectively, or that in the course of the transaction, he had threatened to cut PW2 money. It is no doubt that true that A3 had accompanied A1 on that day in question, but there is no material on the basis of which it can be held that A3 had done so, fully well knowing that the deceased Jairam and PW would be attending the magistrate court on that day. Here also they didn't know that they would take that path. There is no evidence to show that the other accused knew that he had a knife in his custody. There are no even
Oral dying declaration.
oral declaration says both. So both is not possible. So whether can we rely on that?
Is supposing a person is being attacked. Say one is holding a knife. Will he be able to be in a position to really think of he's holding the knife? No, he's the one holding the knife. He'll only be trying to be defending himself from two persons.
Yes.
Yeah.
So
But both of them are
prosecution
attacking them.
Prosecution has seized the knife. They could have established the fingerprint, Your Lordship.
Hmm?
They could have established the fingerprint which person has stabbed it. They have not done that. So now by drawing
In a wooden handle, will a fingerprint remain?
that I don't know, Your Lordship. That they have to say that fingerprint was not possible.
Have you taken this issue up before the trial court?
No, my argument is that there is no evidence. If Your Lordship, may I continue with this because the other.
Lordship, being a PP, my duty is to place it before the court, whatever is on record. Since the IO has not, Lordship, he has deposed at page 35 that PW1 Rumi Saikia did not state before him.
Page 35.
Yes, my lord.
Page 35. Yes.
Rumi Saikia did not state before me that her deceased husband shouted as Morilu, Morilu, Morilu or Rumi, and at that time she went to the place of occurrence. This witness also did not state before me that she saw her husband lying under the bridge, smeared with blood, and that with the help of the torchlight taken by of her brother-in-law Benudhar, that is Pulin, she saw the accused persons fleeing away from the place of occurrence. She also did not state before me that she called one Pradip Soikia, with the help of whom she and her brother-in-law brought out her injured husband from under the bridge. Lordship, just now I have perused 161 statement. If a lordship permits, then I can place it before
Yes,
the
yes.
court. They may get a benefit under 304 part 1, your lordship.
Why?
Lordship, because there might be grave and sudden provocation on the part of the other side, like the accused person. Lordship, from the statement given by at the first instance, Rumi আছিল, no? Lordship, may I read the vernacular portion? Lordship, statement of complainant Rumi Saikia, মোৰ নাম আৰু ঠিকনা ওপৰত কোৱা মতে সত্য, মোৰ বয়স 30 বছৰ, মৃত বিমল শইকীয়া মোৰ স্বামী আছিল। মোৰ ক'ব লগা এই যে যোৱা ইংৰাজী 23/1/2018 তাৰিখে ৰাতি প্ৰায় 8:30 মান বজাত গাঁৱত চিঞৰ বাখৰ শুনি মই ওলাই আহি গম পাওঁ যে মোৰ স্বামী বিমল শইকীয়াক চুৰিৰে আঘাত কৰি দলঙৰ তলত পেলাই থৈছে। মই লগে লগে হাস্পতালত নিব লাগে বুলি মোৰ সম্পৰ্কীয় দাদা প্ৰদীপ শইকীয়াৰ ঘৰলৈ তেওঁক মাতিবলৈ যাওঁ। ঘূৰি আহি মোৰ আঘাতপ্ৰাপ্ত স্বামীয়ে কয় যে তেওঁক নিপম ফুকন, পেটাই আৰু প্ৰবীণ ফুকনে তেওঁক মাৰধৰ কৰি চুৰিৰে আঘাত কৰে। তাৰ কিছু সময়ৰ পিছত তেওঁৰ মৃত্যু হয়। তেতিয়া ৰাইজে উত্তেজনা হয়, নিপম ফুকন, পেটাই আৰু প্ৰবীণ ফুকনক কৰায়ত্ব কৰি উত্তম মাধ্যম সোধাই পুলিচক সমঝাই দিয়ে। মোৰ স্বামী দোকানলৈ পাণ কিনিবলৈ যাওঁতে নিপম ফুকনে কৃষ্ণতাঁতী ঘৰৰ সন্মুখত বেয়া মাতেৰে গান গাই থাকোতে মোৰ স্বামীয়ে কিয় বেয়া মাতে গান গাইছ বুলি কোৱা। They were like singing some slang songs, my lord. So,
What do you mean by slang?
lordship, maybe I'm
No, how-
wrong in বেয়া মাতেৰে গান গায়।
Songs having bad meaning.
I know.
They were singing some songs, dirty
Yes.
songs.
These two accused persons, yes.
Songs.
Dirty
Don't,
songs.
you see, you're using the wrong word.
I'm so sorry, your lordship.
It's different.
My lord,
Meaning of slang is
my lord.
It's
So
a
dirty in
song.
dirty songs.
Okay.
So like he asked, গান গাই থাকোতে মোৰ স্বামীয়ে কিয় বেয়া মাতে গান গাইছ বুলি কোৱাত, as he said, why you are singing dirty songs, then দুইজনৰ মাজত কাজিয়া হয়। There was fight. In 161 statement, lordship, I'm reading, your lordship is to
161 statement of
this one, Rumi, informant. The first person who visited the place of occurrence.
The wife.
Yes. Then Nipon Fukone Surire Bimal Hoikak Aghat Kore or Olopasa Bimal Hoikar Mitupasa Police Rise Dequai.
Okay, so they were
Oh, this
they
is
were
the
singing
good-
song, they were in a happy mood, and this
Wait.
fellow,
Yes,
this stuck-up fellow, he comes and spoils their mood.
My lord. Lordship. So, Pradeep Hoikar,
Correct?
another witness, Pradeep Hoikar, PW2. He also states, apart from other lordship previous.
What does he say?
মোৰ নামৰ ঠিকনা ওপৰত কমতে সত্য মোৰ বয়স 45 বছৰ মই ব্যৱসায় কৰো শ্ৰীমতী ৰুমি শইকীয়া মোৰ সম্পৰ্কীয় ভন্টি হয় আজি ইংৰাজী 23/1/18 তাৰিখে মই ঘৰত আছিলো ৰাতিপুৱা 8:30 মান বজাত ৰুমি শইকীয়াই মোৰ ঘৰলৈ আহি মোক জনাই যে তেওঁৰ স্বামী কোনোবা মানুহে মাৰি আঘাত কৰি ৰাস্তাৰ দলঙৰ তলত পেলাই থৈছে মই দৌৰি গৈ দেখা পাওঁ লগে লগে চিঞৰ-বাখৰ হোৱা সকলো ৰাইজ গোট খাই তেওঁক দলঙৰ তলৰ পৰা উঠাই আনো আৰু তেওঁক খুটপুচ কৰা তেওঁ বিমল শইকীয়াই কয় যে পেটাই আৰু প্ৰবীণে উপজুপৰি মাৰপিট কৰি মোক চুৰিৰে আঘাত কৰিছে আমি 108 পুলিচক খবৰ দিও যদিও ঠিক পুলিচ অহাত 10 মিনিট মানৰ আগত বিমল শইকীয়াৰ মৃত্যু হয় পাছত গাঁৱৰ সকলো ৰাইজে
Just one thing, PW2 also says what? That same thing? No.
yes
That they were singing dot.
yes মই পাছত গম পোৱা মতে নিপম ফুকন পেটায়ে অতিৰিক্ত মদ খায় নিপম ফুকন is drinking a lot your lordship গাঁৱৰ ৰাস্তাত বেয়া বেয়া মাতেৰে অশ্লীল গালি গালাজ পাৰি গৈ থকা অৱস্থাত বিমল শইকীয়াই সৰু ল'ৰা কিয় ইমান বেয়া মাত মাতিছ as we're using like dirty languages he said he questioned why you are like you being a small kid why you are using dirty language then
So they heard this.
yes
Okay, so basically, okay,
so I leave it to your lordship
the disease was basically pontification. I mean, yeah, na? Telling
Yeah,
him,
that's
hey,
a
you should behave, you should be well mannered,
Hello.
so. And so he spoiled their drunken mood, I think. Okay, that's all.
that's also it
So PW1 and PW2.
161 statement. Although the IO said, he said nothing has been stated. So it's my duty to go through it, your lordship. And if your lordship,
It had been stated to him.
yes,
That it had been stated to him
it has not come up on evidence on record.
that they were singing dirty songs
Yes,
and using abusive or dirty language or abusive language,
lordship.
which due to which they were reprimanded by this
My lord.
disease.
My lord.
Correct?
My lord.
APP, I think, wants you to go out under.
No, my duty is to point out whatever is on record, your lordship. Not to defend or support anybody, your lordship.
Lordship, one important thing that has come out, the police arrived at the scene on that night itself,
So,
After 10 minutes.
after
so
10 minutes.
how does it matter?
The FIR was lodged as per the prosecution story from the.
There might have been a,
No,
there
no,
might
what
have
I-
been a, there might have been a phone
FIR
call.
delay, no, yeah, what I'm on is that story as the police came on the next day, entire story. There is no evidence to the effect that, however, what I mean to say, there is some doubt in the.
So probably there was a GD entry made.
No,
at the
GD
base
entry,
of
no,
a-
GD entry is also next day, 11:20. What I am on lordship, your lordship may see page 82. The inquest report was 10:45 AM.
Ah.
FIR and GD
Yeah.
entry is 11:20
The time,
AM,
date.
next day. Next day, that is 23.
They must have got some information.
Information, but then they should have made a
They should have
GD
made
entry.
GD entry.
And also the challan for,
How is that prejudiced?
no, not prejudice. What I mean to say that the prosecution story is not watertight. There is, it comes from the 162.
No prosecution story is ever watertight.
And also in the challan for sending the body for examination is also 24:11 AM prior to FIR. Under GD entry,
Reference to GD entry.
GD entry to 11:20, yes.
Lordship, so lordship is aware of the TT Antonis method. They proceeded on the GD entry.
No,
Nothing
proceeded-
is wrong.
No, GD entry is also the next day.
No, on 23/1. Date of occurrence is
No, but
23/1.
what is-
Date of occurrence is 23/1.
One.
GD entry from the record 23-1, GD entry 628.
No, but here see, GD
Maybe
entries.
there might be
and-
some wrong, but original record.
Can be two GD entry.
No, I'm not on that.
One is based upon the information received and one is based upon the FIR.
No,
They could have made two GD entries.
I'm on that,
number
the 161 statement gives a correct picture, that's what I am.
No.
That will help.
Basically, but then, so 161 can basically be used to discredit the witness or predict.
Earlier statement, yes.
So if that, so if your lordship is on part 1 or part 2, then common intention, I'm on common intention.
Can we act upon the 161 statement?
But the discrepancy pointed out by the,
Discrepancy can be there, but discrepancy only to the extent that they were singing that that the PW 1 and 2 did not mention about the apparent singing dirty song.
that's why I'm on common intention, your lordship. If the common intention is not there, then prosecution has not established who had stabbed. And I am on my
Doesn't have to have, it doesn't mean that every common intention, supposing there's a common intention of 100 people to kill one person. It doesn't mean that all 100 of them will have to have.
that's a that's a free for all. Then individually the motive
No,
has to
no.
be proof.
No. Supposing one person says, those that community person, they're bad. Supposing, just listen. So 100 of those community persons gang up and they say we are going to kill this person. And only one person kills it. Does it mean that 34 cannot be applied?
No, very much attracted in that case because they have gang up to kill that person.
Here
There is a
also,
mo-
here also, they were singing, then he abused them. So, you see, common intention can occur at the spur of the moment. It doesn't
yes.
have to occur 2 days earlier or something. Then,
That's why I'm relying on this, then whether the common intention has been proved by the prosecution, because there cannot be any hypothetical conclusion. That's what your paragraph 10 that I have relied on, there are other two judgments also.
but then what 106 say? When the knowledge is known to you specifically, it's your duty to speak up the truth.
That has come up in PW 6.
No.
They already,
106 requires you to speak up the truth.
that,
Anything else?
I'll just then pass on the judgment.
Yes.
Paragraph 10 is whether they had knowledge that they will take the path, the disease would take that path, they had no knowledge. The other accused had no knowledge that the other person was carrying a weapon, the kind of injury, and also the conduct pursuant to that. So these are the grounds that we'll have to check. Here in my humble submission, the both the accused being together,
You see, there is no denial of the fact that there was no intention of it. There was no intention. No one is saying that there was any intention to speak. It only occurred after being reprimanded, that reprimand had been made. It's only after that. Prior to
Yes.
that, there was nothing.
even for spur of
It
the
is
moment.
not their case, it is not their case that there was any intention to kill. It is only their case that after they met and started quarreling or talking, that this thing.
So to deduce the intention, you'll have to see the conduct just prior, at the moment and after. That's what I mean. This judgment, paragraph 10,
Yeah, what does it say?
may I read them?
It only talks about their action. What is the law?
See, it is, if I may read from it, the 5th, 6th line, it. It is no doubt that A3 had accompanied A and OA1 on that day in question, but there is no material on the basis of which it can be held that A3 had done so, full well knowing that disease so and so would be attending the magistrate's court on that day. So first is, if a lordship, the first is they should know that he would take that part. Now, again, if I may, lordship, calm down. So there, just if lordship, bear with me if I read it. And it was for the purpose he had accompanied A1 and A2 to the bazaar street. except that he was on a friendly terms with A1, A3, had no scores to settle with Jayaram or PW1. He also no score to settle. A3 had not assisted A1 and A2 in any manner in the attack. So is there any proof that the other had assisted the other accused in any manner? That has not come out from the evidence. He had not even uttered any words.
Next, carry on.
He had not uttered any words of instigation when 2% were cut. So instigation is also not been established, Your Lordship. So if
Yes,
8, 9, 10 is the law, I'll just 8, 9, 10, 11. I'll not read entire thing, Your Lordship. 8, 9, 10, 11.
next. Okay. Yes, para.
Plus 7.
Oh, again. Yes,
Paragraph 7.
yes. Okay, that's
This 7 deals with escaping after the incident. Even a innocent person tend to escape after the incident. Still, that cannot be a ground to infer that there is commonality of
so,
design.
so both of them should be what? Should be acquitted.
I am on I am saying there is no evidence against my accused to establish these facts.
So according to it, is there any evidence against your co-accused?
That
No, no, asking you. If the person who died had named both of you at the escort,
Yes.
and you were the both of you, one of you, according to you, is the cause of the death. Then if only two of you remain, and if you are innocent, what does that make your partner?
Your Lordship, then the dying declaration has to be specific. Here, what
Yes.
they are saying,
And declaration,
they are saying
Specific.
that 2% has done it. See, there one other judgment of the Supreme Court where acquittal was given because they have to say the manner. Here, what happened? They are saying both the person have assaulted. But whether both the person could have stabbed, that's the question.
if supposing, I'm just asking you a question. Supposing two persons, one with a knife, assault one Mr. A, and he died. Does it mean that only the person who was holding the knife
No.
would be guilty of
Other
murder?
would also be guilty if we can establish there is some covert act. Covert may be either
The dead person has said that both of you have assaulted. He doesn't know who is holding the knife.
but there is no injury of assault. There's no other injury. Only injury is this stabbing.
Yes,
Two injury.
correct.
What I mean to say, whether that person, that statement could be taken, veracity can be relied because the
You see,
judgment should
that
not.
doesn't mean that in each and every assault, that every slap or every hit would result in some injury to the body.
I'm,
Now, if you visualize the situation, you see the night time,
I,
when you were there. He just asked him that why you're singing bad songs or dirty songs or why you are drinking and whatever. In that case, if one slaps in it that way and the other one was holding the tape, stabbing, how can you say that there is no common intention? Yes, pipe along the back. That can be one.
Okay.
Meet please, your lordships. Your lordships, on the last occasion, I have submitted before your lordships regarding the dying declaration. And the other was interested and related witnesses. These two things. Today, your lordships, I'm grateful to my learned senior friend that she has shown the 161 statement because that is what I was going to rely upon.
Okay.
Because if your lordships, with your lordship's permission, if your lordships allow me to read the 161 again. Your lordships, page number 35.
Yes.
Your lordships, 161 is not annexed, but then the deposition of PW11 speaks about 161 statement which was deposed before him. Your lordships, PW1, page number 35, PW1, Srimati Rumi Sekia, informant, did not state before me that her deceased husband shouted as Murilu or Murilu. And at that time, she went to the place of occurrence. This witness also did not state before me that she saw her husband lying under the bridge, smeared with blood, and that with the help of the torchlight taken by her brother-in-law, Benudar, she saw the accused person fleeing away from the place of occurrence. She also did not state before me that she called one Pradeep Sekia, with the help of whom she and her brother-in-law brought out her injured husband from under the bridge. Your Lordships, first of all, I would like to say, since she was the first person to visit, and Your Lordships, if the statement which she has given, the statement is at page number 10, her statement. If Your Lordships, is if I may take Your Lordships to page number 11.
Yes.
Sorry, Your Lordships, page number 10. Your Lordships, at that 1, 2, 3, fourth line, Your Lordships. At that time, my husband called me as I am dying Rumi. I immediately went to the place of occurrence and found my husband lying in a pool of blood under the bridge when my brother-in-law, brother of so-and-so, Benudar Sekia, who accompanied me, flashed a torch he carried with him. The accused persons fled from the place of occurrence. Seeing my husband in that condition, my brother-in-law and I thought my husband was alive. As my brother-in-law and I could not lift my husband from that state, I went to the house of Pradeep Sekia in a run and called him to the place of occurrence. After arrival of Pradeep Sekia, we somehow managed to lift my husband's dead body to the road under the bridge on a changi, a bio-like frame used to carry dead body or other things. The 161 statement which she has given and the deposition which she has given before the court, she has given for the first time. And Your Lordship, it is clear, it is very much clear that her statement is a made-up story and an afterthought. Because she has stated before the police and before the police and the court, it's completely contradictory, Your Lordships. What she has deposed before the court is for the first time. And there's contradiction. And also, Your Lordships, the contradiction also leads to an omission. So your lordships, first I want to say that her story is a made up story and it's an afterthought. Second, is that she has deposed the same thing before the court for the first time. And your lordship, the credibility of the PW1 is also highly questionable. Because at one place, before the police, she is stating something else, and before the court, she is stating completely a different story. So, your lordship, her statement cannot be relied upon. This is what I want to submit before your lordships today. Secondly, your lordship, secondly, my humble submission is that the entire case is based on dying declaration, which is a very weak piece of evidence, and it cannot be relied on without corroboration from independent witnesses. Lordships, in the present case, your lordship's dying declaration was not made before any independent witnesses. Your lordships, if I may take your lordships to page number 11, the cross part, your lordships. Your lordships, down below 1, 2, 3, 4, 5. Your lordships, at the time of incident, from down below, 5th line.
Yes.
At the time of incident, many people were there at the place of occurrence, including Pradeep Sekia and Nabha Sekia. So here she is saying many people were there. But your lordships, even though many people were there, their testimonies has not been taken into account. And so here, your lordships, since it's a public place, where huge gathering as stated by PW1, at least one independent witness, your lordships, could have deposed the dying declaration.
This incident, this gathering of people was later on.
Your lordships, at the time of incident.
Correct. At the time of incident can be, at the time of incident doesn't mean that it has to be just when the incident started or just when the incident ended. So around that time.
Your lordships, in common parlance, I would understand at the time of the incident was very much when the incident has taken place. Your lordships,
I don't know. It's
Also-
very subjective. Hmm.
yes, sir. Lordships, however, all the witnesses who has deposed about the dying declaration were related and interested. And their presence at the place of occurrence is itself not free from any doubt. So all the related witnesses are interested in the outcome of the incident case, which I want to submit before your lordships. Also, your lordships, on the last occasion, I have submitted before your lordships a judgment, your lordships. So there are certain parameters which has been laid down. So, since the allegation is of a serious nature, your lordships, 302 is involved. So, the trial court should have been more careful in arriving at the finding of guilt because of all the issues like your lordships. Number one, the issue is whether the person making the statement was in expectation of death. Number two is, your lordships, whether the dying declaration was made at the earliest opportunity, rule of first opportunity. Number three, your lordship, is whether there is any reasonable suspicion to believe that the dying declaration was put in the mouth of the dying person. Number four, your lordships, whether the dying declaration was a product of prompting, tutoring, or leading at the instance of policy or any interested party. Your lordship, here I'll pause, because what I believe is the 161 statement which he has given and the statement which he has deposed before the court, it might be a result of tutoring and prompting.
Okay, we accept your contention, suppose. PW1 evidence is gone.
Yes, sir.
What about 2, 3, and 5?
But your lordship, she is the prime, even though there are other witnesses
One
also,
is enough.
but she's the first person to visit the place of incident, your lordship.
You see, you don't count the evidence.
Yes, your lordship.
You have got to see the quality of each witness. PW1, okay, we say that she is not reliable. Even if she is not reliable, what about 2? What about 3? Yeah, you cannot train your guns on only one which can say that she is not reliable.
Your lordships,
And say that because one is not reliable, the same paint has to be applied on all the others. You know?
correct, your lordships. Your lordships, if I may take your lordships to page number 12, which is the statement of PW2. Your lordships, if I may read. I know the informant. She is a relative of mine. I also knew deceased Vimal Sekhya. I also know both the accused. Around 8:30 p.m. on 23rd January 2018, the incident took place. At that time, informant Rumi Sekhya came to my house in a run and informed me. So Rumi Sekia, PW1 has informed him that only, Your Lordship, and that someone had inflicted cut injuries to her husband. That also she is not aware of who has inflicted. She's saying someone has inflicted.
Correct.
On the basis of assumption, she is saying, Your
Correct.
Lordship.
You said someone, what is wrong with saying someone has inflicted? In fact, if she said that, so what is wrong if she says someone without naming the person? She doesn't know.
Immediately, I, along with the informant, went to the place of occurrence and found that the informant's husband, Vimal Sekia, was lying in a moribund state. So he was already dead under the bridge. At that time, informant Rumi Sekia,
Moribund means what? What is the meaning of moribund?
Lordship, he was already dead.
Look at look at ask your uncle Google.
Your Lordship had already clarified on the last day. If this has been wrongly written, the correct word was Porias.
No, I know. What is the definition of moribund?
And also in
What is the definition of moribund?
it's morbid state.
I don't know. Let's be very clear. You see, it does not, it basically does, it does not, it does not prove that someone is dead. Does not prove that someone is dead. There's that motionless or something. That,
It says at the point of death, not
that's what, no, does not prove
That
that
means
dead.
more care.
more.
Motionless, basically. Or basically, in a morbid, yes, in a lifeless type, but not exactly there. So that's why you've got to be very careful with your understanding of the word. So we should always use the help of Uncle Google.
Yes, Your Lordship.
Yes.
And the statement which she has, her evidence before the court is nothing, Your Lordship. I would like to submit, it is just an improvement for her from her 161 statement. before the
PW one to okay, gone.
court. Yes, Your
Now
Lordship.
let us go to 2 and 3 and 5. How do you attack their evidence? And remember, that's the part about the oral dying declaration. That has not been, that has not been,
Challenged.
huh?
Has not been challenged, my lord.
No, no, has not been challenged, but that part has not been shaken at all. There
Yes,
isn't
my
any
lord.
evidence of,
And let us not misunderstand, lordship. I have stated,
maybe with regard to going under the bridge and that part may not be there. But with regard to the oral dying declaration, PW1 had heard it.
lordship, in 161 statement, although it was not disclosed that they were using dirty language, that part is only missing. As Assamese, সেই সময়ত আছামী দুজনে মদ খাই পেলাই ৰাস্তাত অভদ্ৰামী কৰি আছিল মোৰ স্বামীয়ে তেওঁলোকক হুলস্থুল নকৰে গৈ so it will not entire thing will not go.
Anyway, yes,
Also,
anything else?
also, Your Lordships, if I may take Your Lordships to page number 75.
75. Yes.
Your Lordships, this is a Caesar list. So the description of seized articles is one knife with cover plastic. Approx. This breadth, the width, nothing has been mentioned. With nail of ounce,
What is
Not
nail of
bad.
ounce? What is
there's no blood stain.
What is nail of ounce?
Your Lordship, I have researched nail of ounce.
This is costly translation.
Why don't you look at the original, Caesar list?
One knife,
Page 75.
Page 75, Caesar list.
nail of ounce. Nail of ounce.
Null is the handle. Approximation with null of,
Nal is the handle, my lord.
ounce, what is ounce?
One knife with cover, plastic, approximately long with inch, something inch. Along one,
Ounce must be in inch.
no, inch.
That's what.
Inch along one. Matchbox was also says, matchbox.
Okay,
Can we have a look?
no, it's okay.
Milo.
Okay. So.
So
madam,
here the breadth with nothing has been mentioned.
huh?
The breadth with nothing has been mentioned about the knife. The knife, Your Lordship, which has been used, the measurement of the knife, like how much long it was.
How does it matter? You are not question, you are not saying that this is not the knife. Have you said that this is not the knife during your cross examination?
And also, Your Lordship, blood stain, there's no, if they have recovered, they could, they definitely would
They might
have.
have wiped it clean. How do we?
Statement that means, the blood stain.
PW4.
Yes, my lord.
PW4.
PW5. Just on 5, please. The bus is set here.
Oh, 5 inches.
That's all? Madam, anything else?
Also, Your Lordship, they have been in the jail for, my client has been in the jail for the last 7 years, 14 months, 9 days, Your Lordship. He's already reprimanding.
7 years, 14 months? How can it be 14 months?
7 years, 8 months, sorry, Your Lordship. 8 months, 19 days. So, Your Lordship, he is already reprimanding. Your Lordship may consider after taking into account all the
How do we do that?
Lordship.
How do we do that? He's convicted under 302. How do we lessen the sentence?
Your Lordship, he is already reprimanding. Your Lordship.
The only way to do it is either we acquit him or it comes and it somehow 304 is a fact. Yes,
I'll be placing on the point of section 34, 2022, 7 SSC 521. From para 9 to 19, Lordship talks about discussions have been made as regards section 34, my lord. I'll be relying on para 9. I'll be relying on para 9 to 19. I'd like to read only 2 paragraphs, Your Lordship. I'll not take much time with Your Lordship. Para 9. In Suresh. Para 9. It starts as, my lord.
yes, para 9.
In Suresh and another was the state of Uttar Pradesh, 2001, 3 SCC 673.
Para
I know.
9.
Manupatra, my lord. There is ship in Suresh, my lord, the parastar says.
Para 13.
My lord.
Yes.
In Suresh and another was the state of UP, 2001, 3 SCC 673. RP Sethize in his concurring judgment for himself and BN Agarwal J on the question of common intention has observed. Section 34 of the Penal Code 1860 recognizes the principle of vicarious liability of criminal jurisprudence it makes a person liable for action of an offense not committed by him, but by another person with whom he shared a common intention. It is a rule of evidence and does not create a substantive offense. The section gives statutory recognition to the common sense principle that if more than two persons intentionally do a thing jointly, it is just the same as if each of them had done it individually. There is no gainsaying that a common intention presupposes prior consent, which requires a pre-arranged plan of the accused participating in an offense. Such pre-concert or pre-planning may develop on the spot or during the course of commission of the offense, but the crucial test is that such plan must precede the act constituting the offense. Common intention can be formed previously or in the course of occurrence, and on the spur of the moment. The existence of a common intention is a question of fact in each case to be proved mainly as a matter of inference from the circumstances of the case. Then para 18, your lordship, it starts at section 34 Indian Penal Code, makes a perpetrator. It talks about the same. It develops at the spur of the moment. It may develop at the spur of the moment. Then another citation on common intention, 2010 10 SSC 407. Virendra Singh is state of MP.
Para?
Lordship, I'll be relying on para, my lord. The wrong paragraph, 18 to 34 and 44 also. Lordship, may read 44, it talks about spur of the moment factor.
The spur of the moment is there in the earlier judgment.
Here also.
What do you want
Lordship
to-
may not rely on that. Then another is on the grave and sudden provocation factor. Vijay versus State of Inspector of Police, my lord.
Y'all don't have any citations on grave and sudden provocation. Or exception for.
I have given one regarding verbal abuse.
Lordship, para 20. May I read from para 18.
Yes,
Exception 1 of section 300 states that a culpable homicide is not murder if the offender, whilst deprived of power of self-control by grave and sudden
Para-
provocation. It starts exception of section para 18. Exception 1 of section 300
16.
states that a culpable homicide is not murder if the offender, whilst deprived of power of self-control by grave and sudden provocation, causes death of the person who gave the provocation or causes the death of any other person by mistake or accident. It is para 19. It is well established that exception 1 to the section 300 can apply when the accused is shown to have deprived of power of self-control by grave and sudden provocation, which is caused by the person whose death has been caused. Para 20. It is not each and every provocation that will reduce the crime from murder to culpable homicide not amounting to murder. The provocation must be both grave and sudden. In order to invoke the benefit of the exception, it must be established that the act committed by the accused was a simultaneous reaction of grave as well as sudden provocation, which deprived him of the power of self-control. If the provocation is grave but not sudden, the accused cannot get the benefit of this exception. Likewise, he cannot invoke,
You tell me, madam,
my lord,
whether the provocation of this fellow telling them
my lord,
or scolding them, reprimanding them,
my lord.
can it be said to be a grave provocation?
It may not be, my lord, because in evidence just come, he only advised them to go home, my
So
lord,
if it is not a grave provocation,
lord.
then where is the question of
my lord.
exception 1 to 300 being applicable?
It not be applicable. And lordship, they were using weapon, dagger. Lordship, it was used by them, my lord.
Initially, you were saying that maybe it can be done.
Lordship, because my duty is to point out 161, because the IO has said it was not deposed before him. So it was my duty to go through 161 statement, my lord. Once, if your lordship,
Both of you are amicus. Both you also.
Your lordships, I have got one judgment. Your lordships was now asking about exception 4. If there is a judgment, your lordships, I would like to place.
Exception 4.
Yes, your lordships. That deals with the applicability of.
Is there a requirement of a fight in exception 4?
Your lordships,
Is there a requirement?
lordships, para 11 will speak everything. It is 2003, 9 SCC 322. It's 2 judges bench judgment.
Para?
Para 11, your lordships. That's the sole para which your lordship has asked. Judgment. Your lordship, if I may read.
Covers acts done in a sudden fight. The first line itself.
Yes, sir. But if I may read, your lordship.
First, you've got to prove whether there was a sudden fight. There's no point reading the first line. Fourth exception to section 100 covers acts done in a sudden fight. So if there's no sudden fight, there's no question of, there's no point reading.
But fight has not been defined. In the
Okay, you define fight.
Lordship, if I'm
Okay.
The fourth exception of section 300 IPC covers act done in a sudden fight. The said exception deals with the case of prosecution not covered by the first exception, after which its place would have been more appropriate. The exception is founded upon the same principle, for in both there is absence of premeditation. But while in the case of exception 1, there is a total deprivation of self-control. In case of exception 4, there's only the heat of passion, which clouds men's sober reason and urges them to deeds which they would not otherwise do. There is provocation in exception 4, as in exception 1, but the injury done is not the direct consequence of that provocation. In fact, exception 4 deals with cases in which, notwithstanding that a blow may have been struck or some provocation given in the origin of the dispute, or in whatever way the quarrel may have originated, yet the subsequent conduct of both the parties puts them in respect of guilt upon an equal footing. A sudden fight implies mutual provocation and blows on each side.
Please read that again, that sentence,
Lordship, which
the last one, the last.
sudden fight
Yeah.
implies mutual provocation and blows on each side. 2003.
So, what does it say? Just read it slowly again.
Your lordship,
Right?
A sudden fight. A
If
sudden
fight-
fight implies mutual provocation and blows on each side.
Blows on each side. Was there blows on each side?
It's from both the sides.
From what do you mean? Yes, from both the sides. So, is there any evidence that there were blows from the deceased to the apparent? So when you cannot have a one-sided fight. I've never heard of a one-sided fight. I mean, of course, a fight like in a boxing match there is. But in a fight, usually both sides try to hit each other. Whether they miss, that's a different thing. But the blows come from either side.
In this case, there was some verbal altercation which has been taken place.
Now, out here, the word says blows. Blows are not verbal altercation. Anything else, madam? Then you come down below also it says here. A fight is a combat between two and more persons, whether with or without weapon.
With or without.
Combat. Combat. The word is combat. Not verbal altercation. That's all.
Lordship, para 30 of judgment just now I have placed 2025. Para 30.
Para 30.
Your Lordship, the sentence starts as, the deceased is said to have uttered. Paras me very much.
Para 30.
Lordship, my Manupat,
30.
the deceased is said to have uttered.
Para 28.
Lordship. The deceased is said to have uttered some bad words, and it appears that he also raised his hand and slapped the appellant herein. However, that by itself may not sufficient to bring the case within the ambit of great and sudden provocation. So, under exception 4, which size gives the provocation doesn't matter, my lord. But here, Honorable Supreme Court has observed, even if there was a lordship using some bad words, my lord, and appears he also raised a hand and slapped the appellant. However, that by itself may not sufficient to bring the case under exception. That grave and sudden provocation.
That's all.
Ma'am.
Heard cases. Hearing concluded, judgment reserved. We heard Mr. R. Sharma, learned counsel. It's there in the last line, Miss S. Sharma.
Yes, sir. Sir, I'm for criminal appeal 74 of 2009.
You are not a legal aid counsel.
It was appointed, he was appointed because A. Kalita was earlier there by your lordship.
So why haven't you asked to be appointed as a legal aid counsel? You are. You can get some.
Well tried, my lord.
Yes, because I have noticed
Yes.
this side. Is gone through various judgments.
Mm.
Okay.
Deeply observed.
Very good, Guru Charan. Maybe those. huh? Those good. You keep this in the. Look. Keep this in the. Huh? Keep it. You just keep it together. This also. Yeah.
Item number two, Lordship, I apologize, Lordship, we have missed the item, our name has not been shown in the copy. Lordship, let the matter be fixed in the next week by showing the name of.
Let it be in the month of November, Lordship, because November we are expecting that 50% will be completed. Our 50% term may be completed in the month of
When
November.
do you want?
November, Lordship, anytime, November.
Okay, right, on the prayer of the parties. List the matter on 3rd November.
Lordship, name of the PP, P Kotoki and PP data may be shown.
Why?
Special
Special
council,
Special
yes,
council.
special council.
For your bill.
Not bill, Lordship, I would mean, otherwise there is a chance of missing their item in the call list.
Oh,
Today, Lordship, I have missed the item.
oh, okay. You don't want it in the, okay, for the future, for the registry to reflect. And the name of Mr. PP Data
And P Kotoki.
and P Kataki as counsel for the,
And it's special public.
as special public, purpose, as special people. That's all.
Obliged.
Deeply obliged.
It's not like earlier during our time, we had to give that order for making our bill. So it was, yeah, our name had to be there.
Yes, Lordship.
Otherwise, we did not get our fee.
Lordship.
Yes,
May it please, my lord. My lords, the appellant before your lordship, my lords, he's been alleged of matricide, my lords, killing his own mother. At the time of the incident in the year 2018, the appellant was 26 years old, my lords. 26 years old, and the complainant, the informant, was the father of the accused, my lords. Now, my lords, before
informant is father.
informant is the father.
Informant is father. Appellant mother.
Yes, the date of incident was 29/07/2018.
With 29,
07/2018. FIR was lodged on 31/07/2018. And
so there is no denial of the fact.
yes, and
Cannot deny because there were many witnesses.
there were 11 witnesses examined, my lords.
No, eyewitnesses, how many?
Eyewitnesses were there, my lords. I'm not referring to the eyewitnesses.
How do you know?
There were, my lords, 2 eyewitnesses, my lords.
2 eyewitnesses
3 eyewitnesses. I'm so
Okay.
sorry. 3 eyewitnesses, my lords.
out of 11.
Out of 11, PW1, PW4, and PW6.
PW1, 4 and
4
6.
and 6. Now, my lords, I'm trying to contend, my lords, that my lord is aware, my lords, chapter 5 of the IPC provides for the exceptions.
Acha.
Exceptions. Now, section 84 in chapter section 84, my lords. Section 84, which is one of the exceptions, my lords. It provides, my lords. May I read, my lords? 84.
Yes.
Act of a person of unsound mind. Nothing is an offense which is done by a person who, at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to the law. Now, a bare reading of 84 would suggest, my lords, if a person at the time of the incident is incapable of knowing the nature of the act, or whatever he is doing, he does not know that action is wrong or contrary to law. Now, my lords, since 84 is an exception to the general rule, there is always a presumption against the exception. There's a presumption that a person who has committed an offense is sane, my lords. That analogy can be inferred from section 105 of the Evidence Act. If I may kindly read, my lords. 105 of the Indian Evidence Act. One zero five. Burden of proving that case of accused comes within exceptions. When a person is accused of any offense, the burden of proving the existence of circumstances bringing the case within any of the general exceptions in the Indian Penal Code or with any special exception or proviso contained in any part of the same code in any law defining the offense is upon him, and the court shall presume the absence of such circumstances. So, my lords, there is a presumption regarding sanity. However, my lords, that presumption is a rebuttable presumption, my lords. That presumption can be rebutted, and the onus is on the appellant or the accused to rebut the presumption.
Yeah.
Now, again, my lords,
Yes.
Section 105 uses the phrase shall presume. Shall presume. Now, shall presume has been defined in the Evidence Act, my lords. If I may kindly read it, my lords, once. Section 4, shall presume.
Section 4.
4. May presume, shall presume, conclusive proof. So I'm reading shall presume. Whenever it is directed by this act that the court shall presume a fact, it shall regard such fact as proved unless and until it is disproved. Now, my lords, I say that the rebuttal of the presumption, in rebutting the presumption, unlike the standard of proof, which is beyond reasonable doubt in convicting a person, but the presumption, the rebuttal of the presumption, the standard of proof is less. It is preponderance of probability. I say so because, my lords, proved and disproved have also been defined by the Evidence Act. I'll read, my lord, disproved, which my lord would find in section 3, the number of legal terminologies, my lord, which has been defined, and disproved is also there. A fact is said to be disproved when, after considering matters before it, the court either believes that it does not exist or considers its non-existence so probable that a prudent man ought, under the circumstances of a particular case, to act upon the supposition that it does not exist. So the prudent man test is laid down, and that is the reason why, my lords, for rebutting the presumption, my lords, the standard of proof is not very strict. It is preponderance of probability. However, my lords, the primary proof that beyond reasonable doubt which rests on the presumption, rests on the prosecution, has to be proved, my lords. I'll come to the facts, my lord. I'm just highlighting the legal points. When you rebut when someone takes a plea of insanity under one of the exceptions, section 84, there is always a presumption regarding the sanity of that person. The court will presume that he is sane unless and until that presumption is rebutted. Now, for rebutting that presumption, the standard of proof is preponderance of probability and not beyond reasonable doubt.
From where do you get this? Preponderance of probability.
But there are judgments, and the judgments, this analogy has been derived from the meaning of proved and disproved, because the meaning of proved and disproved lays down the prudent man test, my lord. A prudent man, so it is not beyond reasonable doubt. But the general burden, my lord, there are two burdens, my lord. One is the general burden, which is upon the prosecution. And what is that burden, my lords? That it has to be proved beyond reasonable doubt. That is the general burden. And the special burden in the instant case, which is section 84, that has to be discharged by the appellant or the accused to rebut the presumption, but that there, my lords, the standard of proof is not beyond reasonable doubt, but it is preponderance of probability. Now, my lords, for
Let us see the judgments which say that
yes. Before coming to that, my lords,
the presumption.
to place the case in perspective, my lords.
Let us be very clear of this
Yes.
maxim that you are trying to.
Yes, I'll come to that, my lord. But it'll be more clear, my lord, more lucid, my lord, if I narrate the facts once. For
Let us be clear of the law first.
my lord.
You're basically saying
Yes,
for rebuttal of the
presumption.
presumption, the standard of proof required
Yes,
is preponderance of probability.
probability,
Where is
and not.
where
I'll
is
directly come to that. My lord, may kindly take up. I'll add what as it's copies of the judgment. It's a full bench judgment of the Honorable Supreme Court.
what do you mean full bench judgment?
My lord,
Full bench of a supreme, what do you mean full bench?
my lord, rendered by.
I've not heard of a full bench. What is a full bench? How many
Not
judges?
to
is a full
confuse a
bench?
constitution bench or a full bench is more than two, my lords, I suppose. Constitution is 5 and or is the
Constitution
other
is five. Constitution is five.
5.
There are 3 judges bench. There are 2 judges bench. I have not heard of a full bench.
My lord,
I can understand full bench of the High Court,
my lord.
not in the Supreme Court.
My lords, my mistake, my lord. Construed it.
No, even I don't know. I'm asking you.
I was researching, my lord, I'm always confused because constitution bench is 5 judges
Correct. There's no full bench.
and more than
There's
2,
a 3 judges bench.
3 judges or 4 judges.
Otherwise, if you say 3 judges are full bench, what would you call 4 judges bench?
Yes. Yes.
What
Yes.
will you call a 4 judges bench? Anyway,
Yes, ma'am.
yes, where are we?
My lords, I'm referring to the 3 judges bench, my lords,
Yes.
judgment. Well, just give me a moment. My lord may directly come to paragraph. My lords, the pages are marked. Paragraph 5, but my lords, the next page after paragraph 5, when a person is bound to prove. My lord has it, my lords.
It's a new paragraph.
New paragraph 101, my lords. It says 101. Page 3 of the SEC online judgment.
Page 3. Here we have got page 3.
Whoever desires, my lord, starts with
When a person is bound to prove.
when a person is bound to prove. My lord has it? My lord. When a person is bound to prove the existence of any fact, it is said to be the burden so and so. So from the next line, it is a fundamental principle of criminal jurisprudence that an accused is presumed to be innocent, and therefore the burden lies on the prosecution to prove the guilt of the accused beyond reasonable doubt. That's the, my lords, the general burden, my lords, beyond reasonable doubt. The prosecution, therefore, in a case of homicide, shall prove beyond reasonable doubt that the accused caused death with the requisite intention as described in section 299 of the Indian Penal Code. This general burden never shifts, and it always rests on the prosecution. But as section 84 of the Indian Penal Code provides that nothing is an offense if the accused at the time of doing that act, by reason of unsoundness of mind, was incapable of knowing the nature of his act, or what he was doing was either wrong or contrary to law. This being an exception, under section 105 of the Evidence Act, the burden of proving the existence of circumstances bringing the case within the exception lies on the accused. The court shall presume the absence of such circumstances. Under section 105 of the Evidence Act, read with the definition of shall presume in section 4 thereof, the court shall regard the absence of such circumstances as proved unless after considering the materials before it, it believes that said circumstances existed or their existence was so probable that a prudent man ought under the circumstances of the particular case to act upon the supposition that they did exist. To put it in other words, the accused will have to rebut the presumption that such circumstances did not exist by placing materials before the court sufficient to make it consider the existence of the said circumstances so probable that a prudent man would act upon them. The accused has to satisfy the standard of a prudent man. If the material placed before the court, such as oral, documentary evidence, presumptions, admissions, or even prosecution evidence, satisfies the test of prudent man, the accused will have to be discharged. The evidence so placed may not be sufficient to discharge the burden under Section 105 of the Evidence Act, but it may raise a reasonable doubt in the mind of the judge as regard one or other of the necessary ingredients of the offense itself. It may, for instance, raise a reasonable doubt in the mind of the judge whether the accused had requisite intention laid down in Section 299 of the Indian Penal Code. If the judge has a reasonable doubt, he has to acquit the accused, for in the event the prosecution will have failed to prove conclusively the guilt of the accused. There is no conflict between the general burden, which is always on the prosecution and which never shifts, and the special burden that rests on the accused to make out his defense of insanity. Now, my lord, if my lord skips another paragraph, my lord. And comes to my lord's page number, paragraph 7, page number 6. There it has been again clarified. Paragraph 7, page number 6. my lord. The doctrine of burden of proof in the context of plea of insanity may be stated in the following propositions. The prosecution must prove beyond reasonable doubt that the accused had committed the offense with the requisite mens rea, and the burden of proving that always rests on the prosecution from the beginning to the end of the trial. There is a rebuttable presumption that the accused was not insane when he committed the crime. In the sense laid down by Section 84 of the Indian Penal Code, the accused may rebut it by placing before the court all relevant evidence, oral, documentary, circumstantial, but the burden of proof upon him is no higher than that rests upon a party to a civil proceedings. So, the special burden for rebutting the presumption that the standard of proof.
So where is that phrase, preponderance of probability?
My lord, because
It is the test of a prudent man that is.
yes, no, my lord,
Preponderance of probability.
yes, I'll clarify that, my lord. So it clearly says
That is what has to be, that is the,
yes,
that is what you're trying to get at.
exactly. My lords, the relevant evidence, oral or documentary, circumstantial, but the burden of proof upon him is no higher than what rests upon a party to civil proceedings. In civil proceedings, it is preponderance of probability, and in
No. Sorry, not a civil proceedings.
yes, my lord.
It is that to
Service law, my lord.
law.
No, in civil proceedings also I'll have another judgment also. I'll come to that. I'll clarify that.
This judgment doesn't
Yes.
of preponderance.
Yes.
will be
I'll-
anywhere.
Yes, I'll come to that.
Please come to the law
Yes,
which provides that
If-
for rebutting
yes,
a presumption
yes,
with regard to the exception provided,
yes.
the
The exact word preponderance of probability,
standard of proof that is
Yes.
required is.
or if I can show through judgments that the standard of proof in a civil,
That is what you're trying to say, no, in
Yes,
the very
yes,
beginning.
yes.
Then should have.
yes,
Why you
and
wasting time?
or my lords, I have to show my lords that the standard of proof in a civil proceeding is preponderance of probability. That would also satisfy my lords. If in a civil proceeding it's preponderance of probability. No, yes, my lord. It's the judgment says that
This is a criminal proceeding, Mr. Kaul.
I understand, my lord, but
Beyond.
with regard to presumption,
Correct. You show us, show
Yes.
us the law. Show us the
my
law.
lord would give me 1 minute.
Correct. Yeah.
1
We'll
minute.
give you 2 minutes.
Yes. Times.
Can you?
Yes, madam.
We'll just go out.
No, just.
Yes.
Unfortunately, 2018 SEC. Here, my lord, the court has referred to the earlier judgment, what I referred to, and used the exact phrase preponderance of probability. I'll read it out now.
Okay.
It- Sah- 18 SEC, by the way, 18 SEC. 18-7 SEC 718. Devidas Lokar Rathor. My lord, may directly come to paragraph 10. This is one copy, I'm so sorry. May I read, my lord?
Yeah.
Because the law undoubtedly presumes that every person committing an offense is sane and liable for his act, though it is specified circumstances, it may be rebuttable. The doctrine of burden of proof in the context of plea of insanity was stated as follows in Dayabhai so and so. That's the earlier judgment, which I referred to. Lordship may skip that and come directly to paragraph 11. I already read that portion, my lord, in the earlier judgment. Copies have been supplied, my lord, the earlier judgment.
Yes.
Paragraph 11, my lord. After referring to Dayabhai, my lord, Section 84 carves out an exception that an act will not be an act of offense if done by a person who at the time of doing the same, by reason of unsoundness of mind, is incapable of knowing the nature of the act or what he is doing is either wrong or contrary to law. But the onus on the accused under Section 105 of the Evidence Act is not as stringent as on the prosecution to establish beyond all reasonable doubt. The accused has only to establish his defense on a preponderance of probability.
But it said as observed. Where is it observed? I think this is a wrong committed.
No, my lord, there are other. I'm so sorry. I'm so sorry.
No, 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 no.
Yes.
Yes, here.
Yeah.
The accused has only to establish his defense on a preponderance of probability.
As observed
That's what the
in Surendra.
Mishra. Now let us see Surendra Mishra.
But I don't have Surendra Mishra. with me.
Let us see.
Yes.
Surendra will call for it.
Yes.
Where is the, yes.
2011 11 SCC 495. 11 SCC 495.
If in Surendra Mishra it is there, then it's okay.
Yes. And also, my lord, with the deepest respect, my lord.
Only one copy.
To law for even SCC only, no?
Para 13.
No. Surendra Mishra, no?
Para 13.
It's there.
Para 13.
Okay. Now, my lords. Now, my lords, it would appear, my lords, that the primary burden which rests on the prosecution, that is beyond reasonable doubt, and that is there all throughout the trial.
Right.
So the prosecution has to prove that 302, the ingredients which is there in 299, are attracted, and 30 he is liable for punishment under 302. But while rebutting the presumption, the standard of proof is not as strict as the prosecution. It is,
Your part.
yes, on my part, when I rebut it, the court would just see, or rather apply, the prudent man test. And what are the materials, my lord, which the court would consider to see whether the plea of insanity is really there or not? Now, that is also there in Dayabhai, my lord. I'll come to that. But it clearly says, my lord, that the accused may rebut it by placing before the court all relevant evidence, oral, documentary, or circumstantial. But the burden of proof upon him is no higher than what rests upon a party to a civil proceeding. Now, my lords, to rebut the presumption, the court has to consider, with all due respect, my lord, the court has to consider evidence, oral, documentary, or circumstantial. Now, if there were evidence, oral, documentary, or circumstantial, which would suggest that probably the accused is not of sane mind, or at that, during the commission of the offense, he was not sane, then, my lords, the accused has to be acquitted. Now, there's another point, my lords, which Dayabhai, my lords, in the judgment which has been incorporated, my
You
lords.
see, at that time
Yes,
of the trial, did you submit any document?
no document, no.
Did you submit any application?
But no, that again, I'll come to that, my lords. That application, I'll come to that, but evidence, the court refers evidence, the court ought to have inferred it from the PWs, the 313 statement, and the witness given by different prosecution witnesses. I'll come to that. That's why I was referring to whether from the
Because you see, there is what
Yes.
asking.
yes,
Because a person has been suffering from some mental instability or whatever.
Hmm.
Prior to or after the incident does not mean.
Exactly.
At the time of.
my lord is correct.
Was,
My lord is correct. So from the evidence,
Huh?
it has to. My lord is saying the symptoms have to have proximity with the incident. Correct, my lord? During that,
No, not exactly. What I'm saying is
Yes.
just because you were supposedly insane prior to or having some problem prior to or after the incident does not ipso facto prove
exactly.
that you were having that same problem
Yes.
at the time the incident occurs.
Correct, my lord. In fact, my lord, what fell from your lordship, there are judgments, my lord, which says, my lords, they differentiate between medical insanity and legal insanity. That is the point. Medical insanity, a person may be insane, but at that particular point, at the time of the incident, whether he was whether it was of such a nature that he could not, he was insane at that point of time. That is legal insanity. Now, it would appear from the evidence, my lord. And there's another point, my lord, which that Daya Bhai judgment lays down, my lord. The first Daya Bhai says, my lord, the first prosecution, the primary burden, general burden will be on the prosecution. The special burden, again, like my lord submitted, it's not beyond reasonable doubt, but it's preponderance of probability. My lord, there's a third ground also, my lord. Daya Bhai judgment, it has laid down. Now, accused may not successfully discharge the burden, my lord. There may be cases where the accused is not able to discharge the burden fully. Even in that case, my lord, because one of the ingredients of 302 is intention. I'll read 299, my lord. It says there has to be intention or knowledge.
300.
Yes, 300. That
99 is culpable.
culpable 300. That intention has to be there. So the question of mens rea comes, my lord. Now there can be cases where the appellant does not fully discharge the burden under 84, but while trying to discharge, it may raise some doubt in the mind of the court that one ingredient, which is mens rea, was not present. Even if that happens, he's liable for an equity. Now, my lord, I'll quickly.
So in a case of murder, these two are the two major things that are required: mens rea and actus reus only.
Yes. Now, my lord, would come to the paper book for a moment, my lord.
So you are given this. What is it? What-
I have given.
Oh, you have given.
Lordship, that application preferred by the,
Okay.
and the order passed by this honorable court, there are two orange color, Lordship may have a look.
Medical or what has this? I don't have.
From the records. The record of all this.
I'm not privy to that, my lord.
Let's go.
The part of record.
Okay.
Lordship and the order passed by the honorable trial court.
I have seen that. So this application was there.
Yes.
Then
Then that order was passed.
on the
On
basis
the
of
dep-
this application.
Yes.
This is an application that he might be mentally unstable and he should be examined. But the magistrate says, on talking to him, he seems to be a sane person.
Then, my lords, there's a clear violation of section 329. The moment a plea of insanity is raised before the magistrate, it is his bounden duty to refer him to a psychiatrist or to get an examination done. That was never done, my lord. In fact, my lord, surprisingly, on the date of the incident, he was not arrested because he had slit his own throat. And he did not try to run. He slit his own throat and he was mumbling some mumbo jumbo, my lord, and he was taken to the hospital. He was there in the hospital for 1.5 months. And in the 313 statements, when he was asked, what did you do? He said, I don't remember. I was tied to the bed. In AMCH, I was tied to the bed and I was told that I killed my own mother for 1.5 months. And surprisingly, my lords, The doctor who examined him, the medical report was never produced, my lords, during the trial, which gives rise to 1114G,
The,
Well,
huh?
which gives rise to a presumption under 1114G, a negative presumption,
114G of?
the Evidence Act, my lords, which says, my lords, if the evidence which is relevant was not produced, the court can court may,
Did you cross-examine them on this point?
my lords.
Did you cross-examine
No,
the
yes,
IO?
the doctor was never
No, the
produced.
lawyer, not you, the lawyer.
No, lawyer was not never cross-examined. The
No,
prosecution.
the lawyer, didn't the lawyer for the accused
Yes.
cross-examine the IO on this point?
No, no. He was, no, yes, it's there. Cross-examination is there. It's there. Exactly. My lord catches. My lord, I'll just a moment, my lord. The exact point is answered, my lord, by the. It's my lord would find it at page 26, the IO. He clearly says. The cross-examination, my lords, the date of occurrence so-and-so, the ajar was lodged, there's delay in so-and-so. Thereafter, the accused was admitted to Assam Medical College Hospital on so-and-so and was discharged on so-and-so. It is correct that I have not examined the doctor at the oil hospital who treated the accused, nor I had collected any medical report from the said hospital. And Lordship would also see the 313 statement.
He gave his confession statement.
Yes, 313, my lords, the next page.
No, was not recorded.
It's there, my lord, page 27. Examination of the accused.
But he says here that it was not recorded.
No, the
No, confessional statement under 165.
No.
no,
He remained silent, your lordship.
no.
Do not be recorded.
He was examined under 313, my lords.
That is a different thing.
Yes.
That is
Yes.
that. 313.
And he admitted that he murdered his mother. my lords. Page 27, it's there.
Okay, when a person submits an application for medical examination, test whether he's of unsound mind or not. What is the requirement of law?
Yes, 329. So there is a judgment of the Honorable Gujarat High Court, my lords, authored by Honorable Justice Pardiwala, my lords. The few paragraphs they have succinctly discussed that point. Can I place it? my
This
lords?
is,
The relevant portion that I could.
he has not got any Supreme Court judgments, only that. But it has referred to Supreme Court judgments.
Yes. Far more relevant to court.
How long is the judgment?
40 pages, so I'm just referring the relevant pages, not waste pages, man. Yes. Pages are marked at the bottom, page 11, 12, 13, 13 and 14. That should suffice. Judgment says, no, even the plea is not raised, even then it is the duty of the magistrate or the
He is not raised, if they show signs.
signs, yes.
If they don't show signs, where's the requirement?
Yes. The 313, he was asked, why did you kill her? So he stated that my son, he was crying and I don't know what happened. I got angry and I killed my mother. And the father, the complainant states, my lords, there's no previous quarrel with the mother, the victim. So mens rea or motive is also not there.
So what is this case number, this one?
Case number is, my lords, it's a division bench decided on 18th of March 2019. Criminal appeal number 474 of 2019.
474 of 2009.
2019 division bench, my lords. JB
State of Gujarat versus Manjuben,
State of Gujarat versus Manju Ben.
daughter of
Daughter of
Kasturbai
Kasturbai.
Nanjibai.
Yes, yes.
Yes.
Paragraph 22.
Ah.
Page 11, my lords, at the bottom. From the above, it can be seen that in terms of section 1 of section 329 of the code, if at the trial of any person before a magistrate or court of sessions, it appears to the magistrate or court that such person is of unsound mind and consequently incapable of making his defense, the magistrate or court shall, in the first instance, try the fact of such unsoundness and incapacity. And if the magistrate or court, after considering such medical or other evidence as may be produced before him, is satisfied of the fact he or it shall record a finding to that effect and shall postpone further proceedings of the case. Subsection 1 of section 329 would apply when it appears to the magistrate or court.
Okay, if it appears to the magistrate.
Yes, my lord.
The problem is here,
Yes,
the court has held that he appears to be a sane man.
yes, that is perverse. That is perverse.
Why?
Because the 313 and the other evidence, he should have inferred from the evidence, my lord.
No, but when out here also,
Yes,
just because a person writes an application
Hmm.
does not mean straight away he has got
No, no.
consent, unless you are giving some document in proof.
my lords,
Out here, this judgment that we have produced is that if it appears to the.
no, I'll read further, my lord.
Aye.
Yes. My lord may come to the paragraph 23. The provisions contained in section 329 serve an important purpose of not proceeding a trial against a person who on account of his unsoundness of mind is unable to defend so-and-so himself. It is not difficult to appreciate that such requirement would be mandatory in nature. The proceeding against a person of unsound mind and holding him guilty of criminal offense would clearly be violative of the guarantee contained under Article 21 of the Constitution that no person shall be deprived of his life or liberty without following so-and-so. We take notice of the fact that trial court ignored or overlooked something very important, and the omission on the part of the trial court has rendered the judgment and order of conviction and sentence susceptible to the complaint that the same is illegal and deserves to be quashed and set aside. We have perused chapter so-and-so. The chapter starts from section 328 and ends at section 339. We are also conscious of the distinction of defense raised under section 84 of the so-and-so. If a plea of insanity is raised by the accused, it is the duty of the prosecution to subject the accused to a medical examination immediately. My lords, I've been told by my learned senior PP, my lords, there's an application. It's not in my record.
It is.
So, my lords, it says, my lords, if a plea of insanity is raised, now again, the judge is not the expert, my lords, to decide in a way, my lords. I'm so sorry, my lords, to decide whether a person is sane or not. So the best possible way is to make an inquiry by a doctor, my lords.
No, but then that would, you see, that. What is the date of the
Date of the application is 8/3/19.
8/3/19? And the incident occurred on 29/7/18.
Yes.
Now, can it, with the examination done in 2019, can it relate back to 2018?
Yes, it cannot, but it would, of course, throw some light, my lords. So in that,
That throwing some light will not help.
So-
That is the very essence.
yes. So,
You see, that is where
Hmm.
the Supreme Court, I think, they have got various judgments.
right.
It says that just because some person was, just because it could be proved that he had some medical insanity or unsoundness of mind prior to or after the incident, does not prove that he had the same
Exactly,
condition at the
Exactly,
time.
I agree.
That-
But it would have corroborative value. That has to be read with
But
the,
now it didn't
Yes,
put
yes.
it in the date.
my lords, in my humble submission, my lords.
So what is the difference between legal sanity and
Yes,
medical
I'll
sanity?
come to that, but this point raised by my lord, but if I may kindly,
Yes, yes.
well, in that case, my lords, the deepest respect, my lords, section 329 would be rendered mandatory because in all cases, the examination is not done on the date of the incident. In a way, my lords.
Correct.
Yes.
But then it was your duty also.
The duty of
but
an
you
insane person, my lord. Now, my lord, if the judgment is read,
There one very important aspect. There was no medical report with regard to the accused person at the time he was in
At that
hospital.
Or previous?
No, no,
Oh,
no, no.
at the time,
As soon as he
AMCH,
killed, yes,
Lordship,
then
it was not exhibited. I have found some medical doctor in the record.
let us-
and my lord, there.
You were talking about 329 of?
The CRPC, my lord.
Lordship, these are the,
This is the medical thing.
it's on the suicidal injury which has been caused by him,
That is on him.
my lord.
Acha, but there was no test done on him.
No plea taken, only that plea, but without any basis, my lord. And on being
That's-
asked, he gave reasonable answers
That's what the judgment
as like a
says.
prudent man.
That's what the judgment says. First, I have read it out. If a plea of insanity is raised, so first it has been raised. Now the court goes further and says, my lord, we are afraid we are not in a position to accept such submission. Even if the accused had not raised such a plea, and even if the defense counsel had not bothered to look into it, still if the materials on record in the form of documents disclose something about the mental condition of the accused, then it is the duty of the trial court to look into the materials and ascertain the capacity of the accused to enter the defense in accordance with the provisions of section 329 of the code. The satisfaction of the trial court should be recorded in so many words. Now, my lords, even Dayabhai clearly says, my lords, because how will you ascertain insanity at that point of time? It says from evidence, documentary, oral, or circumstantial. Now, my lords, all the prosecution witnesses, the father states, my son did not have any quarrel with his mother. All of a sudden, he slits her throat, then he slits his own throat. Then the investigating officer says, when he comes to the spot, the accused is mumbling some mumbo jumbo. He's not trying to flee. He's not trying to flee. And in the 313 also, my lords, is it, with all due respect, the trial court ought to have inferred something of, my lords. When the accused says, my lords, first he says, yes, I have killed my mother. Then he says, why did you kill? So I don't know why I killed. I came to know when I was in the hospital tied up to the bed. I was told that.
But what is now what can we do? What can we do now?
Yes, my lords,
That part.
because, my lords, like a prudent
Can we
man,
turn back the clock?
no, like that prudent man test, my lords. Now, if these circumstances
Now,
raises some doubt,
Ah.
and that doubt, my lords, again, it's not beyond reasonable doubt. So,
but that,
some probability, if my lord has some doubt that there's some probability
but
that person was
that-
not,
No, that doubt
yes,
now relates to a period 2018.
yes,
Now it's 2025.
yes. And he's incarcerated, my lord, 26-year-old. He needed good mental, my lord,
But then, you see, the problem is him. Some are very good actors also.
yes. No, my lords, here everything has to be related. Why would someone kill his own mother when the witnesses say there was no quarrel with the mother? Then he'll slit his own throat. That cannot be acting, my lords. 1.5 months he was in AMCH.
Maybe due to his regretted his action and then.
Exactly. There may be lot of permutations and combination,
That is what.
but the law, the statute, with the deepest respect, my lord, says that's why you don't have to go beyond reasonable doubt.
But show us
If
how,
this,
show us how, what can we do now at this stage?
yes, my lord, because the plea of insanity was not considered by the
Well-
trial judge in the right perspective.
Was never raised also, was
No.
never,
Yes,
was never taken into issue, was never taken into account by you also.
I myself is someone who's insane, my lord. I'm a village simpleton, my lord.
See, yeah, the council is there.
No, I'm a village simpleton from interior village of Assam.
The council is a prudent man. Supposed to be a
Yes.
prudent
The
man.
insanity was raised during the arguments, my lord. The trial court notes it and brushes it aside, saying 313 he said everything clearly. So, my lords, here, my lords, a 26-year-old, my lords, look at the investigation, my lords. He was there in.
We don't know the reason, you see. When a very rich person from Bombay can be thrown out by his son, the day all the entire family business is given to him.
That is greed, my lords.
That would also amount to,
So that is greed, my lords. That is sheer greed, my lords. That's not insanity.
out here, he's killed for what? We don't know.
No gain. The witnesses would speak, my lords. There's
Okay.
nothing. Nothing. Village simpleton, my lords. Poor boy from our interior villages.
In this case, in America, where this person, 46 years old, is suing his father. That his father should pay him $50,000.
Or let him stay.
Or let him carry on staying in his father's.
We are very lucky that way, my lords.
Father say, why should I pay my own son? Let him go out and work. Anyway, so we don't
My
know.
lords, I'll try and.
That is, you see, it seems quite odd for the appellant to have killed his mother for no apparent reason.
There's no motive. There's no motive, my lords.
Motive is not required. Lordship, eyewitness's account is there. No.
So
That's why
what I'm trying to say is that it's not a question of, so what he's trying to say is that there being no motive, it appears that he was the one sound mind.
Exactly. That's why 84, my lords.
Otherwise, why would you do something?
Lordship, in 313 he says,
It
Lordship, he says something.
is wrong.
Ah, wait, hold on.
I said, should we do it after that?
Yes, madam.
No, 1 o'clock on it.
Hmm.
Yes, madam.
Yes, Your Honor, item number 5, Your Honor.
Ah.
Because my case speaks on mediation process has been failed.
Fail.
No, failed. So talks are going on between both the parties and I have taken the consent of the other parties. So matter is fixed on 6th of November.
Okay, yeah, no, but you said it's failed. If it's failed, what talks will go on?
Some monetary negotiations are going.
Okay, yeah, right. Okay.
So that my lords can infer the accused state of mind at the time of commission of the offense. The 161 which throw some light, my lord. With my-
See the evidence of the person.
Yes, yes.
Was there anything there?
Yes, I'll come to that. But may I read you?
Because 313
Yes,
you can say it's an afterthought also later.
yes, but it can be corroborated nonetheless, my lord, with the evidence on record.
Let us see the evidence.
Yes. May I read the 161 first?
161 of
The accused, my lord.
accused. Okay.
Appellate. I request my learned to
Yes, sir.
kindly read it, ma'am.
মোৰ নাম ঠিকনা ওপৰত দিয়া মতে সত্য মোৰ দেউতাৰ নাম দিলীপ কলিতা আৰু মাৰ নাম ৰেখা কলিতা দেউতাই অইল ইণ্ডিয়া লিমিটেডৰ WCCL-ৰ চাকৰি কৰি আছে যোৱা ইংৰাজী 29/7/2018 তাৰিখে পুৱা প্ৰায় 10টামান বজাত মোৰ মায়ে আমাৰ ঘৰৰ ওচৰত ৰাজহুৱা নামঘৰৰ গেটৰ সন্মুখত মোৰ ল'ৰাটোলৈ খেলি আছিল My mother is playing with my kid in front of Namghar on the relevant date.
Date?
On 29th,
No, this 161.
Yes.
Was it
Of
in-
the accused person.
No, when was the
Dated,
date?
my lord, 13/9.
39/18.
Yes.
Yes,
নামঘৰত খেলি আছিল সেই সময়ত
39/18.
yes it was taken 39
Because the killing was done on
29/7.
July.
29/7.
after 2 months
After 2 months, 161 statement taken.
of this accused person.
Because he was in the hospital, my lord. He had to.
It cut it short.
সেই সময়ত মই দাখন লৈ মাৰ ওচৰলৈ গৈছিলো আৰু মোৰ ল'ৰাটো মই মোৰ ওচৰলৈ মতাত সি দৌৰি আঁতৰলৈ যোৱাত মোৰ খং উঠাত দাখনেৰে দি কি কৰিলো মই মনত নাই জানিব পাৰিলো যে মই মোৰ মাক হত্যা কৰিছো
He stated, my lords, that he went to his mother was playing with his son. So he went to his mother, he called for his son, and the child ran away. When he called his son, the child ran away. Then he got angry and he does not remember anything what happened thereafter. And he's saying that later I was told that I killed my mother. So 161, he states there was apparently no, my lords, nothing, there was no mens rea or my lords, any altercation with the mother. The child ran away. That's why he killed his mother. He does not state.
no out of anger he did that
No, he didn't.
no
He does not state.
খং উঠিলে মোৰ
Angry against the child.
because he ran away
So his
yes
anger was directed at the child.
it was not stated but he said I got angry
Angry against whom?
That has to
nothing has been mentioned
But
my lord
it appears that angry at the child for rejecting him. Not the mother. Why should he be angry at the
Exactly,
mother?
exactly. That's what has been stated. The child ran away. He got angry and he stops there. And thereafter he says, I don't remember anything, but I have been told later that I killed my mother. That's the one.
Maybe angry at the mother also because the child's affection was towards the mother.
Whatever,
maybe,
but doesn't seem, my lords, that he is a person
Not a
rational or responsible. I'll come to the evidence directly, my lord. My lord, PW1, who's the informant, the father, page 8.
Yes.
I am the informant. This is Rekha Kolta was my wife. Accused Pabitra Kolta is my son. The incident took place around 10 a.m. so and so. At the time, I was watching TV in my home and my wife was sitting in front of the Namghar community prayer hall near the house. That day, Gopinis, female participants in a prayer, offered khorai to make offerings to a deity on a raised platter at Namghar. Hearing a hue and cry, I rushed to the Namghar and saw my son accused was hacking my wife with a dowel. When I went near him, he also chased me. The deceased was the mother of the accused. Then I called the police station and came and took away the accused. My wife died at the place of occurrence. Exhibit 1 is the Ajahar. I lodge. Exhibit 1 is my signature. Police seized the dowel. I put signature in the seizure list so and so. I have seen the seized dowel in the court today so and so. The cross mallards. I don't remember it now who wrote the Ajahar. I did not get time to see what was written in the Ajahar. I lodged the Ajahar. Some 1 week or 10 days after the incident, the reason for delay in lodging the Ajahar was not mentioned. I do not know what was written in Exhibit 2. I put my signature. The police seized the dowel from the accused. Just after the incident, the accused tried to commit suicide by slitting his neck with the dowel. Lordship would kindly mark that. So thereafter, my lords, no quarrel has taken place between the accused and his mother just before the incident.
Appellant was how old at that time?
26 years old, my lords.
Mother?
Mother, the victim was 46 years, my lords. Now the father himself states, my lords, there was no quarrel and the appellant himself, the accused himself, tried to commit suicide by slitting his neck, which he did, for which he remained 1.5 months in the hospital, my lords. Next, my lord, would come to PW2. But Dr. my lords, we can skip that because I'm not challenging the fact of killing, my lords. PW3, my lords, can also be skipped. Now, PW4 at page 14, my lords. Here, my lords, the second paragraph. I saw the accused slitting his neck himself with the dowel. So PW4 states, inter alia, that she saw the accused slitting his neck with the dowel. Again, my lords, 5 can be skipped. My lord would come to 6, PW 6. PW 6 also states, my lord, the second paragraph. At the time of the incident, I was cleaning the jungle near the place of occurrence, and then the accused came and hacked his mother, and thereafter he slit his neck with the dowel.
But after that, he was seen shouting in the veranda.
Yes, that my lords, the police, the witness of
A very deep cut.
no, because then thereafter, my lords, he was 1.5 months in the
Maybe
hospital.
1.5 months, maybe, but could he be shouting?
Yes. So that, my lords, well, again, PW 9 also, my lords,
Let us see his medical report, appellant's medical report.
that is not on record here, my lord, not in my paper.
Let us see what was the problem of with his neck. What is the injury on his neck?
Yes.
Superficial injury, little blood coming out for effect. Or was it a deep cut?
But from the evidence, it appears, my lords, there's no motive.
Oh, that
Yes.
may be, but we want to see.
Yes, yes.
He could be hiding certain, to hide his intentions and to lead us up the wrong garden path. He might be doing it also. How
He has
to
to be very smart, my lords.
could be, how
Yes,
to
yes,
know?
yes.
Some of them are very smart. He's the only son.
Only son.
No sisters. Only son.
He's married, he has a son.
He is married, has a son.
In 313 also, he states the same thing, my lord. He got angry at the kid, then he does not remember anything, but later he came to know that he killed his mother.
How do you see? How do we reconcile the issue as whether that aspect? Because you see, he was taken before the magistrate,
My lord, he was taken before the magistrate. 161 also, 164 is not there, my lord.
and then
Could not be recorded
Could not be.
because he remained silent.
when
Order sheet says so, my lord. Order sheet.
he remains, he was taken to the magistrate
Yes,
on that
Not,
day.
not on record again.
So he was taken to the magistrate on that day.
my lord.
So won't have been that thing. And then the magistrate would have noticed whether a person is unsound mind or not.
Exactly.
I think you can make out a person by looking at him also. Good.
The session judge also had the opportunity during the 313, my lords. He said it's reasonable, but I'll take my lords to the 313, my lords. A reasonable man won't state that in his 313. And again, my lords, if he wants to hide that he admits, my lord, I killed my mother. He cannot be so smart as to know everything with regard to section 84, 329 to make up a case like that. He states, I killed
He
her.
might be having some lawyer friends. How do you know? Anything is possible.
Yes, again, my lords, that's why, my lords, the burden of proof in 84 is preponderance. If my lord has a little bit of doubt with regard to his insanity, then he's liable for an acquittal.
On 14-9, I'm sorry. 49 case record is received. Seen the order of the learned CJM Dibrugarh for recording of confessional statement of accused, namely Povitra Kolita. The accused is produced before me and was explained to him about the procedure and consequences of confessional statement. The accused is given reflection time of 5 days. Fix 18-9-18 for production of the accused for recording of confessional statement. Then on 18-9, accused Povitra Kolita is produced before me for recording confessional statement. The accused stated that he want to have conversation with his engaged remand some advocate before making the confession. Later, remand advocate engaged to the counsel, make conversation with the accused and jail premises before doing any so and so. Then for 24-9, accused person is produced before me after reflection period for recording of confession statement. The accused person is examined by me to ascertain his mental state and voluntariness by having verbal conversation with him, but the accused has found in fetal state of mind and failed to say that actually occurred at the relevant time though he consented to confess his guilt. And hence, under the said circumstances, I deemed it proper not to record his confessional statement as a version of the some cannot be considered to be voluntary one with sound state of mind. The
Siemens. The magistrate himself is stating that it seems he's not.
Where did, which order?
Lordship ordered it 24
Order dated
24/9/18.
24/9/18?
Yes.
Okay.
In that case, he could not have proceeded. He ought to have followed the procedure laid down in 328, 329, my lords. Because 84 says, my lords, that insanity, like my lord said, my lords, legal insanity at the time of commission of the offense. 328, on the other hand, says, my lords, that at any time if he is found that he's not of sound mind, he won't be able to make a defense. So he should not have proceeded. He should have followed the procedure laid down.
Now, so what is to be done?
Now, my lord, if 84 is made out, then it's a clear case of equity, my lord.
Oh, but how do we just say that it is made out just because that procedure has not been followed?
No, 84 is different, 328 is again different. So 320, a case of
328
is
onwards the
made out.
procedure.
Yes, it's made out. The procedure under 320 is made out. The magistrate himself has said that he.
So what happened?
Yes.
If the procedure under 328 has not been followed, what happened? What is the consequence?
In that case, my lords, it will be a violation of Article 21, constitutionalist right to life, my lords. And there are judgments to that effect. It's a,
So, I mean,
this Gujarat judgment also, my lord, says, part of, I'll just read one paragraph from the Gujarat judgment. Yes, ma'am.
yeah,
My lords, paragraph 23 reads, my lords, the
Yes.
provision contained in Art Section 329
Ah.
serve an important purpose of not proceeding a trial against a person who, on account of his unsoundness of mind, is unable to defend himself. It is not difficult to appreciate that such requirement would be mandatory in nature. The proceeding against a person of unsound mind and holding him guilty of a criminal offense would be clearly violative of the guarantee contained under Article 21 of the Constitution, that no person shall be deprived of his life or liberty without following the procedure established by law. So 328, 329 is attracted, my lords, and also 84, my lords. Attending facts and circumstances, my lord would see everything starting from the 161, the PWs. Here the learned PP has also pointed out, an application was also made, my lord. Clear case of mistrial, my lord. And 84 is also made out, my lord. to determine whether that presumption is rebutted, my lord would take a cue from the attending facts and
How
circumstances.
long has it-
No, since 2018, 3 months, 29, 29/7/18, he was admitted to the hospital.
Is he fit to be is he fit to be let out?
Yes.
No, madam.
If he is
Yes,
mentally unsound,
exactly. I was expecting that question. Ma'am. I was expecting that.
then
But
now,
that
now
court has al-
he'll kill his father this
Mother.
time.
No, my lords. In that case, my lords, he won't be incarcerated in the jail, my lords. Lordship is aware, my lords, mental health issues are not like earlier, my lords. That he has a mental issue, he has to be given electric shock. There are means and remedies for that also.
So, but sure
But
that-
I was not totally prepared, but one paragraph from a judge.
334 says so. See, 334 CRPC.
My lord, Rupesh Manger, 2023 9 SCC.
Provision says so, man.
739.
Provision.
yes, sir.
Sir, Rupesh Manger, sir. My lord. Oh. Paragraph 2, that I'm not calling for. Paragraph 23.
323 what?
334, 335 CRPC. Whenever the finding states that the accused persons committed the act alleged, the magistrate or the court before whom or which the trial has been held shall, if such an act would but for the incapacity found have constituted an offence, order such person to be detained in safe custody in such place and manner as the magistrate or the court. 335 CRPC.
35, okay.
35 A, B, A and B. Then lunatic asylum be also be made. Detention in the lunatic asylum.
But there is another act, no? That
Yes, mental health.
Mental Health Act.
that has that.
The name has been changed, madam. Now it's it was earlier 1985. back in
Prevention.
1985. Sorry. Here, so Mental Health Act was, you know. I provided a judgment, ma'am. So, this copy. One paragraph, ma'am. What is the duty of the court in such cases, ma'am? Paragraph 23. May I read, my lords? 23. In a recent judgment of this court in Prakash Nai versus State of Goa, after reiterating the above principles, it is held that the procedure prescribed in Chapter 15 of the Code of Criminal Procedure, Chapter 15, 84 is contained in Chapter 15, my lords, of the Code of Criminal Procedure, clearly indicates that there cannot be an acquittal on the ground, of unsoundness of mind unless the act is actually done. The whole idea is to facilitate a person of unsound mind to stand trial not only because of his reasoning capacity, but also to treat him as one who is having a disability. The role of the court is to find the remedial measures and do complete justice. The court held in para 17 does, my lord. Having noted the scope and ambit of Chapter 25 of CRPC, including the provisions incorporated by the amendment so and so, one has to take into account the fact that the court has a larger role to play while considering the case under Section 84 IPC. If a friendly approach is required to be followed during trial, when adequate powers have been conferred upon the court to even discharge an accused on the ground of unsound mind, the same reasoning will have to be applied with much force when it comes to Section 84. Here, my lords.
That does not give you the answer.
Now, my lords, we are concerned with two questions now, man. First, my lords, since my learned friend has read out that order where the magistrate himself said,
No, leaving that aside, the
Yes.
question is this. Supposing we come to a finding, yes, that since he was not sent for a test, the entire trial has been vitiated. Now what is to be done? Can we set him free in the, with the,
No, your
we
lordship
can
cannot.
set him free.
Yes, yes.
Then,
I'll-
and can we come to a finding that he was a lunatic at that stage? And what is his stage now?
Yes.
Yes,
That
lordship, let my learned friend make the submission. I have got submissions to make. Whether at the commission or at the time of commission of the crime, he was suffering from insanity.
No, I'm not on that.
Yes, if your lordship holds, my lord.
So now the question is,
Yes.
supposing we hold that he was insane at that time. Now, and we say we acquit him because of section 84.
yes.
Now, what is the next step to be taken? Can we just say that he should be released?
Yes, exactly. This judgment, Rupesh
No,
Mange.
cannot do so.
Yes.
Your lordship may not do so.
In that case, my lords, in this case, Rupesh Mange, the accused killed his own grandfather with a machete. Now, under 84, the court held that under 84, he was of insane mind. And what did the court do? Paragraph 28 minutes, the last paragraph. There's no other way, my lords.
No, but then he's a menace to society.
No.
If he now he'll kill somebody else, again he take the plea that he's insane.
We accordingly set aside the judgment on so and so, passed by the High Court and affirmed that the judgment in acquittal dated so and so, passed by the trial court. We accordingly allow the appeals and acquit the appellant accused.
No, he
of
should be acquitted, but then can he be allowed to roam free?
That, my lord, if my lord gives me some time, I'll do some
Upen
research on that.
Bosumotari judgment of this honorable court. পাব নেকি Upen Bosumotari মনুপাত্ৰত আছে এটি।
Two questions, my lord. Acquittal under 84, if lordship is satisfied
আমাৰ
with regard to section 84, he has to be
ছাৰে
acquitted.
দিছিলে নেকি?
And if it is 329, I have to do some further research, my lord. The trial could not have proceeded, my lord. They could not have proceeded with the trial.
Maybe, but the fact remains is that he killed.
Yes, he killed.
Pension
Yes.
There is no guarantee that he will not kill again. If he can kill one, why not two?
Jail
Why not three?
But my lord,
What?
the mindset
For
is
that-
formative nowadays, my lord.
No, it is so for reforming that person.
ছাৰৰ ন?
Can we just let him loose in this?
Yes. That
Or-
I would
or-
do some research.
Or should he?
Yes.
Or should he have medication, be in some
Yes.
well looked after
Yes.
facility?
লৰ্ডশ্বিপ has passed one judgment.
I know.
Upen Bosumotari.
পঢ়িব লাগিব, মই sorry.
Nothing.
Citation was given.
jail to search for. I have got submissions to make, man. Whether at the time of commission of the crime, he was suffering from.
Now we'll
mental
hear you
symptoms.
now. I think we have heard you. There's nothing much.
That query, my lord, if lordship will have to
No,
give me
that
some.
we'll take it, then we'll take it up after some. In the meantime, you can
Yeah.
look at whatever.
And my lord, few records are not available with me. That order passed by the magistrate by
Will
the
not be available.
160.
Is the council.
Sir,
You, all these issues, you see, if you are not going to complete the argument, you should have never started.
Yes, I'm not.
Because you're wasting everyone's,
My lord.
all the people behind you are waiting their turn.
I'll get a copy from my learned friend.
No, I don't have. the-
Quickly.
Sir, कब आता? বিচাৰা, Upen Bosumotari.
No, the order.
Order to go to a record, right? Go to the commission.
Then he can look from his
My
iPad.
lord, the Wi-Fi doesn't work. The port is no.
Person, this.
लिखा.
সেইটোৱেইটো।
The report is it?
Hmm.
I hope it's a good platform. Good reason. When
Yes, madam, I think you
Yes,
can
Dev.
start.
I'll be reading the provision under section 328 CRPC.
28.
Yeah, 328. When a magistrate holding an inquiry has reason to believe that a person against whom the inquiry is being held is of unsoundness of mind and consequently incapable of making his defense, The magistrate shall inquire into the fact of such unsoundness of mind and shall cause such person to be examined by the civil surgeon of the district or such other medical officer as the case state government may direct, and thereupon shall examine such surgeon or other officer as a witness and shall reduce the in writing manner. So in the present case in hand, when the application was moved before the honorable court, trial court, Lordship, the answers were put to him and he gave reasonable answer, my lord, to the query put by the honorable court. So in that event of the matter, Lordship, there was no reason to believe,
And what,
Lordship.
this was at what time you said?
my lord,
At the time of evidence?
during inquiry or trial.
No, that is all right.
My lord.
In this case.
This, yes, it was on 17, Lordship, may I see the permission? Like, my lordship. Eight, 319.
8319.
Yes.
What happened in 8319?
When the application was moved
Application.
on the ground of unsoundness of mind, the magistrate put a question, this one, order is as follows, my lord. The accused is produced from jail through VC. One PW, namely Chandan Kaur, has appeared and deposed evidence. He is duly cross-examined by the defense side. Let the case be fixed for further evidence, if any, on 18-319. Seen the petition number 337 filed under section 329 CRPC, praying to postpone the further proceeding,
Order dated?
8-319.
And the application also 8319.
Yes.
Oh.
Claiming that the accused is of unsound mind. On perusal of the petition, it is not known who has filed this petition, as the petition has not reflected the name and signature of the petitioner. Be that as it may, when this court had a talk with the accused person, he is found as a person of well-sound mind. He answered all the queries of the court reasonably. Even for a single moment, he is not found that he is incapable of making his defense. He beautifully described his case, including murder of his mother. Therefore, it is abundantly clear that Section 329 CRPC is not applicable. The petition is declared dismissed. When the petition was moved, there was no signature of the accused person. Nobody, just it was placed before the court, your lordship, as it was observed by the learned trial court. And when it was some certain query were made before the accused person, lordship, he gave reasonable answer as like a prudent man. So there was no occasion on the
That
part,
was with regard to 8/3/2019.
lordship.
What about the order passed on 24/9/18? Prior to that? According to police.
Lordship, may I say, it was in the committal stage, lordship, my learned.
But then
judge-
you see,
Yes,
committal stage, you see, in a criminal case, there are two stages. One is the inquiry stage and one is the trial.
trial stage.
For the inquiry stage, 438 is the provision. that
Yes.
is attractive.
My lord.
And for the trial stage, 439. So both of them require this examination to be done.
But it has to be borne, my lord, by some records. Nothing, no petition moved. Although it says on the appearance of the, it was like, it's reflected in the order sheet, my lord.
That
But no medical record, even this one medical document, which is available in the record, which wasn't exhibited.
no,
Nothing.
but then does the section 328 require
Yes.
medical document?
My lord.
For
Because in lordship, my lord, we kindly consider date of occurrence is 18/31/7/18, my lord.
Correct.
29/7/18.
Correct.
FI was filed on 31/7/18.
Correct.
And your lordship 24/9/18 after 2 months.
Correct.
Whether at the time of commission of the crime, whether,
No, but then even at, you see, it was at the stage of inquiry. Correct?
my lord,
If it is at the stage of inquiry, the next step to be taken is the trial.
my lord.
So whether the accused could defend himself properly at the trial stage was an issue that should have been considered by the trial court also on 24/9/2018.
Lordship, 24/9, Yes, if Lordship, the impression of the learned inquiring judge, he is behaving abnormally.
And the order says that order says that he seems to
Some
be.
fecal, like some behavioral aspect was there.
So the two views are possible. Which view are we supposed to take?
Lordship, for end of justice, may I pray your Lordship, although it's in the evidence, Lordship, at the final hearing stage. Lordship, no plea was made by my learned friend also before. What is the conduct of the accused person in jail, my lord? Is he behaving sanely? Or prime factor is but the date of occurrence, your lordship. Whether at the time of commission of the crime, was he suffering from any mental illness? That is the factor, that is the aspect he is to lordship satisfy.
I'm the amicus curiae. I never met the client, my lords. That's otherwise
no,
I
don't
would
have to
assert
be-
it. But
No,
no.
it's not about you. It's about the defense as a
Yes.
counsel as a whole,
Yes.
not you
Yes.
particularly.
Yes.
But the thing is that whatever it is, there has been a lapse.
Yes.
There has been a lapse by the trial court. Or because at the, or whoever the court was, because at the inquiry stage itself, it has made a finding on 24/9/18 that he appears to be a one sound man. So once that finding is there, what does it say 24/9/2018? Just read the relevant portion.
The accused person is examined by me to ascertain his mental state and voluntariness by having verbal conversation with him, but the accused was found in fecal state of mind. Fecal state of mind, you know, and failed to say what he actually, what was, I don't know what actually occurred at the relevant time, though he consented to confess his guilt. Hence, under the say circumstances, I deemed it proper not to record his confessional statement, as the version of the accused cannot be considered to be voluntary one with sound state of mind. With sound state of mind doesn't mean, my lord, he is suffering from unsoundness of mind.
With some state of mind means what?
Not unsound.
Lordship, this observation is given as regards making confessional statement.
So he says that, so you mean to say that she said that, I mean,
He is,
magistrate said that he has got a sound state of mind, is it?
but doesn't, he even didn't say, my lord, he was unsound, he was suffering from unsoundness of mind. It is as regards,
Impression is what? Impression is that. Just read it again, that point.
I deemed it proper not to record his confessional statement, as the version of the accused cannot be considered to be voluntary one. Because prior to that, he talked with his lawyer, my lord, with sound state of mind. The accused is sent back. Let us see it, subsequent order, my lord. Then accused person's Povitro Kolita is produced. Lordship, may kindly see the previous order, no plea, nothing. He was like behaving sane. Lordship, then 49, case record received seen the order of CGM, recording a confession statement of the accused, namely Povitra. Accused is produced before the court and was explained to him about the procedure and consequence confession statement. The accused is given reflection time. Then 18-9. Accused Povitra Kolita is produced before him for recording confession statement. The accused stated that he want to have conversation with his engaged remand advocate before making his confession. Is the conduct insane, your lordship? 18-9, it behaving like normal as a normal human being. Later, remand advocate engaged to the accused shall make conversation with the accused. Then 24-9, lordship, that observation is made.
Why did the court make such observation?
My respectful submission is that it is only as regards making, because he could not decide himself whether he'll make the confession or not.
Difficult.
Nothing is normal in this case. You cannot say it's normal.
There is lapse on the part of the trial court, the prosecution, defense, everybody.
No.
Everybody. Actually, if now first of all, that application also is unsigned. Correct?
Yes, it is there, my lord. No signature of the.
Nothing. No witness. And if we say it is the petitioner, the appellant who made it, then it seems to be a very normal application.
There's no signature, nothing.
Nothing.
Since we're concerned with life and liberty, my lord, it has been
Then every criminal
said many
will come out
many a
with
time.
guilty of insanity.
Yes, my lord, that is the reason why it has to be beyond reasonable doubt. That is the reason why, because it
When
concerns
eyewitness
life and
account
liberty.
is there, your lordship.
No, he is
I'm not
killed.
contesting that, my lord.
He's killed.
Yes,
Yes.
I have killed.
The effect that he has
It is
killed is,
beyond all reasonable doubt.
madam, that's not the issue. The issue is not whether he has killed. That is proved. The issue is whether he is a unsound mind. That's all.
Exactly,
Yes.
exactly.
Every criminal, after committing the crime, after having so many eyewitnesses will come out.
What was he doing?
The
What
painter,
was-
my lord.
Huh?
Painter.
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 And his father?
He
Father,
works in this one, ONGC.
ONGC.
Yes.
As,
not an officer or something.
No, it's submitted, my lord.
as
DLS is ko ba format mo?
no, but one thing is, was the father, you see, the thing is that if he was of unsound mind, his father could have said something.
Yes,
The father said, my lord.
very much there. No,
Not with regard to unsoundness of mind, but he said there was no altercation, my lord. That question was never
No,
posed to
no.
him. Whether he was of
lordship in
unsound mind.
open mosumater judgment, witnesses have deposed his behavior prior to the occurrence. Here, nothing is on record, nothing is on evidence.
Here, my lords, the line of judgments with regard to 84 clearly says that the court would consider the attending facts and circumstances, the PWs, and if there is some doubt, because the standard is less.
Was the father a witness?
Yes,
prosecution
you want.
PW1, man.
So there's nothing that he is
No.
a unsound mind.
No,
No, it was never posed to him. That question was never posed to him.
But he would have known if his father, if he, you see, when someone is an unsound mind, when a child is autistic, you know, straight away the parents know
Yes,
and
yes,
they always
yes,
they
my
bring
lord,
it
but-
out.
And burden lies on the accused person to prove, your lordship, that he was
Exactly,
suffering
that has been
from.
discharged. That is my submission.
What,
84
just merely putting an application, unsigned application will discharge his burden, your
Not, my
lordship?
lords, not in that. Not because of the application. Because, my lords, 84 says if the court considers the attending facts and circumstances and it raises some doubt, in the instant case, he kills his own mother without any provocation, which is there on record, because of his son ran away from him. Thereafter, he slits his own throat. He does not run. When the police comes, he's seen murmuring something. Thereafter, he is taken to the hospital, admitted there, tied to the bed.
Says that he's murmuring something.
Yes. My lords, PW 11. My lord may come to PW 10, my lords, the IAN 11. Very important, my lords. His conduct after the page 23. My lords, 1, 2, 3.
Yes, yes, I've got, please read.
When I arrived at the house of the accused, I saw him shouting at the backyard veranda. I also saw bloodstain so and so. I also seen the cut injury on his neck of the accused person. Thereafter, PW 11 clearly states, my lords, in the cross that he was there in the hospital for 1.5 months. The doctor was never examined. The medical report was never called for.
If you are shouting, if you are at the backside of the house shouting, that would not be, it'd be a very small.
Maybe repenting after whatever has been done.
Huh?
And why would my lords, see, my lords, in my humble submission, my lords, it is not it is not a crime of passion or some revenge, my lord. It's a case of matricide, my lords, a boy killing his own mother. So it has to be looked into with some circumspection, my lords. And these things ought to have been gone through by the magistrate, at least the procedure 328, 329. It's not a simple case, my. Why would someone kill his own mother, my lords, without any provocation, which is on record? That there was no altercation between the mother and the son.
Okay. Okay. What else? Any?
Lordship is closing the matter.
Yes, yes, the problem.
I'll be referring 2023 5 SCC 673.
Huh?
2023 5 SCC 673, my lord.
5 SEC,
673.
Tara,
Para 24. My Manupatra citation. No? 2456.
Manupatra will not do, madam.
Oh, shit.
You always give us SCC citation and you.
No, this is
Manupatra,
it's reported in SCC. Paragraphs may not match. That's the
that is the problem.
Ase, a copy. Print to mail to.
I'll make a compilation, mark the paragraphs, and make a paper book.
Lordship, should I read it slowly?
Not required. We delays everything.
Today, tomorrow, we'll submit it.
Para 4, Lordship, may I read? May not
Yes,
read.
yes, you can read.
Para 2. Raising the plea of insanity on the mandate of Section 84 of the Indian Penal Code 1860, the appellant seeks reversal of the order of conviction passed by the Division Bench of the High Court of Bombay of Goa, confirming the order of Additional Sessions Judge S.G. Morgaon 2, as we are dealing with the seminal issue of applicability of Section 84 of the Indian Penal Code, and in the light of the focus made by the counsel for the appellant, we do not propose to go into the merits. Then para 4, my lord. Section 84 of the Indian Penal Code recognizes only an act which could not be termed as an offense. It starts with the words, nothing is an offense. The said words are a clear indication. Prakash Nai. 5 SCC 673. Such an act shall emanate from an unsound mind. Therefore, the existence of an unsound mind is a sine qua non to the applicability of the provision. A mere unsound mind per se would not suffice, and it should not be to the extent of not knowing the nature of the act. Such a person is incapable of knowing the nature of the said act. Similarly, he does not stand to reason as to whether an act committed is either wrong or contrary to law. Needless to say, the element of incapacity emerging from an unsound mind shall be present at the time of commission.
No, that is the law. That much we know. How do we prove that?
673. And para 5, man. 673. Prakash Nai versus State of Goa. Abo na pa? SCC. Then para 5 minute. The provision speaks about the act of a person on sound mind. It is a very broad provision relatable to the incapacities as aforesaid. The test is from the point of view of a prudent man. Therefore, Mere medical insanity cannot be said to mean unsoundness of mind. There may be a case where a person suffering from medical insanity would have committed an act. However, the test is out one of legal insanity to attract the mandate of Section 84 of the Indian Penal Code. There must be an inability of a person in knowing the nature of the act or to understand it to be either wrong or contrary to law. Paisa?
But yes,
Got it? Like paisa. The aforesaid provision is founded on the maxim actus non ream facit nisi mensit rea, that is, an act does not constitute a guilt unless done with a guilty intention. It is a fundamental principle of criminal law that there has to be an element of mens rea in forming guilt with intention. A person of an unsound mind who is incapable of knowing the consequence of the act does not know that such an act is right or wrong. He may not be even know that he has committed an act. When such is the position, he cannot be made to suffer punishment. This act cannot be termed as a mental rebellion constituting deviant behavior leading to a crime against society. He stands as a victim in need of help and therefore cannot be charged with tried for an offense. His position is that of a child not knowing either his action or the consequence of it. Then, Your Lordship, para 7. We wish to place reliance on the following decisions of this court. Surendra Mishra versus State of Jharkhand. In our opinion, an accused who seeks exoneration from liability of an act under Section 84 of the Indian Penal Code is to prove legal insanity, not medical insanity. Expression unsoundness of mind has not been defined in the Penal Code and it has mainly been treated as equivalent to insanity. But the term insanity carries different meaning in different contexts and describe varying degrees of mental disorder. Every person who is suffering from mental disease is not ipso facto exempted from criminal liability. The mere fact that the accused is concealed, odd, or irascible and his brain is not quite all right, or that the physical and mental ailments from which he suffered had rendered his intellect weak and affected his emotion or indulgence in certain unusual acts, or had fits of insanity at short intervals, or that he was subject to epileptic fits and there was abnormal behavior, the behavior in fear are not sufficient to attract the application of Section 84 of the Penal Code. Then
wait, your paragraph starts from which page? So how does it start?
para 2, my lord, para 2 starts
Para,
raising the plea of insanity on the mandate of Section 84.
that is para 1. Then the
Then
next,
para 4, Section 84 of the Indian Penal Code recognizes only an act which could not be termed as an offense.
that is para 3.
My lord. Then para 5, your lordship, the provision speaks about the act of a person of unsound mind.
It is a very broad provision. Correct?
Yes, my lord, para 5.
Para 4. And then
Okay. Then para 5, I have just quoted. Then para 6, the aforesaid provision is founded on a maxim.
para 5.
Then para 7, my lord, we wish to place reliance on the following decisions.
Okay.
Then Bapu's case, Surendra Mishra, Hari Singh has been cited.
Yeah.
Then para 8, the burden of proof does lie on the accused to prove to the satisfaction of the court. My lord. Then 12 and 13,
How does it start?
we wish to place reliance on the classical decisions of this court in Daya Bhai, Chagan Bhai. Then 13, this court in case of Bapu, it was observed, my lord. Then para 14, this court in a recent decision, Devidas, Loka Rathod,
Yes.
para 14, then para 18, my lord. Para 18 starts as, we find adequate materials on a assessment of evaluation, legal and medical insanity. It has been discussed, my lord. And in the case in hand, in this case referred, Lordship, it was doctors were there which proved which is overlooked by the learned court below, learned division bench. So, Lordship, this matter went in favor of the accused person. Since the accused person could not prove the case that he is suffering from legal insanity, my lord, at the time of commission of the crime, my lord. So in that event of the matter, your lordship, the learned trial court proceeded in accordance with law, my lord, because he sounded like a prudent man. He gave all the reasonable answers put to him. Even in 313, he made the confession before the learned court below. He admitted his guilt, my lord, that he committed the offense. And since there are eyewitnesses account, in the event of the matter, your lordship be pleased to uphold the judgment, the learned trial.
My lord, Dayabhai is the judgment, my lord. It's the locus classicus, my lord. Dayabhai judgment, my lord. It has been referred everywhere. I also referred to the judgment. I have supplied a copy, my lord.
What do you mean, Daya by which one?
So, my lord, one moment, my lord. I have supplied the SCC online judgment. My lord.
Which one?
1960,
Oh,
1964.
the 94.
Yes.
Okay, that's all.
I'll give the judgments tomorrow, my lord. I'll mark the paragraph also.
Is it required? Right. As Mr. P. Mahanta, learned amicus curiae. Also heard Mr. P. Guya, learned additional people. This appeal has been filed against, has just put a challenge to the impugned judgment dated 17/8/2019 passed by the Court of the Additional District and Sessions Judge, Dibrugarh. In Sessions Case number 173 of 2018. By which the appellant was convicted and sentenced under section 302 IPC. And I was convicted and sentenced to undergo imprisonment for life with a fine of rupees 1,000 in default to undergo simple imprisonment for 3. Next para. The matter relates to the killing of the wife of the mother of the appellant by the appellant. By hitting her with a dowel. Which resulted in her death. The father of the appellant was the informant in the present. And in his FIR dated 31/7/2018, he had said that the appellant had hacked his wife with a dagger and thereafter tried to commit suicide by slitting his neck with the dagger. Next. The petitioner's counsel submits that there is no denial of the fact that the deceased had died due to the appellant, bracket son, having killed his mother with a dart. However, the appellant was, however, the act committed by the appellant was not an offense as the said act had been done by due to the reason of unsoundness of mind on the part of the appellant. So he submits that the appellant did not know the nature of the act that was done on his mother due to unsoundness of mind. Some of which attracted the provision of section 84. IPC. Next. The appellant's counsel submits that the appellant had slit his throat with the same dagger after having killed his mother with the same. The incident had occurred on 29/7/2018, and the FIR had been lodged by the appellant's father on
31/7/18 months.
2008. There were 3 eyewitnesses to the incident of the appellant killing his mother. Out of the 11 prosecution witnesses who have been examined by the learned trial. These eyewitnesses were PW 1, 4 and 3. He submits that in respect of section 84 of the section 84 IPC, there is a presumption of sanity on the part of an accused. And that in terms of section 105 of the Indian Evidence Act, when a person is accused of any offense, the burden of proving the existence of circumstances bringing the case within any of the general exceptions in the IPC the court is to presume the absence of such circumstance. However, the same can be, however, the said presumption can be rebutted,
It's a rebuttable presumption.
can be rebutted. We further submit that on the reading of the definition of section 3 and 4 pertaining to the words inverted commas proved, comma, disproved, inverted comma, and inverted comma, inverted commas not proved, comma, may presume, comma, shall presume, comma, and conclusive proof. Inverted comma. The standard of proof required for rebutting a rebutting a presumption under the general exceptions provided in chapter 4 of the IPC. Is preponderance of probability. In support of his submission, the learned counsel of the appellant has relied upon the judgments of the Supreme Court in the case of Dash versus Dash, comma, 1964 SCC online C20. Bracket AIR 1964 SC 156. He submits that the rebuttability of a presumption of the general exception, comma, as reflected in, as stated in the above judgment, provides that the
Paragraph 7, the yardstick has been laid down.
an accused has to satisfy the standard of a prudent man. First of which has been explained to also include within its meaning the test of preponderance of probability. In this regard, he has relied upon the judgment of the Supreme Court in the case of Dash versus Dash, 2018, 7 SCC 71.
One more, which is more precise, man. Same point, only, more precise, preponderance. Paragraph 19.
I'm making it so thick. And in the case of Dash versus Dash, reported in 1974 for SPC 764. Ah. Yes, sir. The learned counsel for the appellant submit. That after the appellant had killed his mother with a dao, he had slit his own throat. Actually, this one. At the time the appellant was arrested by the police, he was found murmuring. The appellant was thereafter taken to the hospital where he remained for 1.5.
1 month, 16 days to be precise.
1 month. it took. The 161 CRPC statement of the appellant was thereafter recorded on
Flag mark the post.
on 13/9/18. What did he say? There is his 161 statement.
He said, my lords, that on the day of the Bhavna, he wanted to go to his child. The child was playing with his mother. So when he went to his child ran away, and then he got angry. Thereafter, he pauses and he says that I don't remember what happened thereafter, but I've been told that I killed my mother. That is the 161.
Wherein he stated that as he called his child,
On the day of the incident.
that he had called his child on the date of the incident. On the day of the incident. When his child was playing with his mother.
Victim.
I said victim. The child ran away. Some of the appellant became angry.
That much.
The appellant thereafter stated that he did not know what had happened. Next part. The Learned counsel for the appellant submit that when there has been a stand taken by the appellant that he was mentally unsound, and when it was known that his actions were not of a prudent man, it was the duty of the learned courts to have the appellant examined by a civil surgeon of the district as to whether as to determine whether the appellant was a unsound man. Who was not only incapable of, who was not only, who could not have been found guilty of committing a crime under section 302 IPC. But who would also be incapable of making his defense before the learned trial. That's all. That's your case.
The informant also stated that there was no altercation between the mother and the
Gustav. The appearance counsel submits that as there was no motive established by the prosecutor. For the appellant to have killed his mother. And the same being supported by the evidence of the prosecution witness. The act of the appellant who was of unsound mind would have to be. What would have to be what? No, would not attract. Section 302 IP. In view of section 84.
and the doctor who attended him was never examined, and the medical report was also never called for where he was admitted.
Okay, right on. The appearance counsel for the subject
It's on record. EW.
that the doctor who had attended upon the appellant for 1 month, 16 days was never made a prosecution witness. Was not made a witness,
And the medical
And-
report was
and the medical report of the appellant for the said period was also never brought on. That's all.
and as such, section 114G is attracted of the Evidence
As
Act.
such, section 114G of the Evidence Act
That evidence which could be produced and not produced would, if produced, be unfavorable.
was attractive. In as much as
One one four is the section, G is the illustration.
one which one?
114G, the illustration, the number of illustrations. G, the evidence which could be and is not produced would, if produced, be unfavorable to the person who
Yeah.
withholds the
Medical evidence is a product, it may go in favor of the accused person regarding his unsoundness of mind. So
That-
this 114G may not be applicable, my lord.
that
I don't have 114G.
It's there, like,
It's-
illustrations,
illustration. Let me take my book.
114.
Okay, the
That is my submission, Malaj. Lordship में एके हो, एके हो.
in as much as the evidence
Here the prosecution had the duty to call for the medical
That's
practitioner. Sorry, Malaj.
the evidence which would be produced had not been produced by the public. That's all. The lab counsel for the apparent that faith that the impugned judgment to be set aside and the appellant should be what, acquitted? Acquitted from the charge under section 302.
Statement of the magistrate, my lord, not my submission, that's why I'm that made.
Ms. B. Buyan, the learned APP on the other hand submits that a reading of the various orders of the learned trial court which show that there was no occasion for the learned trial court to have a suspicion that the appellant was not a normal and prudent person. He further submits that an unsigned application had been submitted to the learned trial court on 8/3/2019. Praying forwarding the prayer.
Please to consider the above facts and circumstances and pass necessary order for examination of the accused by a psychiatric doctor of AMCH until then a trial of the case may be postponed for the end of justice.
On account of what?
Has been facing trial so and so, reverse were recorded accused himself cut his neck and tried to kill himself, but after prolonged treatment, he was recovered. That there are circumstances when he committed the alleged offense and his attempt to suicide, and also the evidence of prosecution witnesses.
See there,
My lord.
was, what is the reason that he wants a psychiatrist? Would have to be. What is it?
Wait, yeah, this. Beautiful, beautiful. Beautiful.
Suggest. Okay, whatever I said. Have been submitted on behalf of the accused to the learned trial court on 8/3/2019. Praying for examination of the appellant by a psychiatric doctor of AMC as the attempt to suicide by the appellant and the evidence of the prosecution witnesses that the appellant had been suffering from, has been suffering from mental illness that however, the however,
Order is flag mark, entry.
is 24/9/80.
No, there is order. Entry.
8/3, my lord, the earlier order of the magistrate.
However, the Assistant District and Session Judge Dibrugarh in his order dated 8/3/2019 and held that besides the petition application not showing who had signed, who had filed or signed the petition, the court had to talk with the appellant where he was found to be of sound mind. The appellant had answered all the queries of the court reasonably. And it was not found even during a single moment, even for a single moment, that the appellant was incapable of making a determination. If the court does tell that section 329 CRPC was not applicable to the appellant. His order has not been challenged.
No, I need not challenge this order, man. The main order of conviction has.
But then when the application for a psychiatrist has been done,
Hmm.
the court has taken a decision that he is of sound mind.
But the earlier order, my lord, does not refer to that, my lord, where the magistrate has stated that he's of unsound mind. And I have also referred to the Gujarat judgment, my lords, where it is said, my lords, once an application is made, it is a duty of the court to get him examined by a doctor. Because the court is not an expert, my lords.
It
How
has
can the
been
court-
formed with records, my lord, some documents to support his contention that he was suffering from mental unsoundness.
Right.
The earlier,
Continue. Right. The next part, the learned APP further submit that the unsigned application made on behalf of the appellant was without any documents, medical document showing that the appellant had suffered or was suffering from any mental problem. Yes, sir. The learned APP further submits that
(24,918).
in the order dated 24/9/2008, the learned trial court, the learned court of the magistrate who was to record the confessional statement of the appellant after after having been given 5 days reflection time. Had stated. And you take this inverted comma from here to there. I'll put it XX, okay? Say XX. This back.
As regards that order, my submission be recorded. As regards that order, my submission be recorded.
For
That
the-
it is as regards confessional statement. He could not decide.
The learned APP submits. This paragraph. That the above order dated 24/09/2018 passed by the Judicial Magistrate First Class Brigadier is only with regard the decision of the magistrate not to record the confession statement of the applicant. As the same could not be, uh, his examination showed that his confessional statement would not be voluntary. Would not be a voluntary one with sound statement. Correct? Yes, next paragraph. Anything else, madam?
Lordship, that after he talked with his lawyer, that is his afterthought, because all along his behavior has never been insane during the trial.
So then the APP submits that there was nothing in the behavior of the appellant during inquiry and the trial to show that the appellant was of unsound mind.
Yes. So the magistrate,
Rather, the appellant prayed that he wanted to have a discussion with his legal counsel when it took order.
the previous order. 24, before
uh,
24.
When the appellant was first produced before the judicial magistrate first class for recording his confessional statement. As reflected in the order dated 18/9/2018 issued by the judicial magistrate. What do I say? The legal counsel, before making a confession, huh?
So there was no reason for the magistrate to believe that he was suffering from uncertainty.
No, first of all, continue. She also submits that there was no reason for the learned magistrate to believe that the appellant was a person of unsound. That's all?
My lord,
So so as to adopt the procedure under section 328.
So as to adopt the procedure under section 329,
328.
328 and 329 CRPC respectively. We are still applying 328, 329, CRPC.
The
and
chapter.
IPC, and we're not using the BNSS.
Yes.
retrospectively. My lords, I also produced that Gujarat High Court judgment. My lord has listed and that has to be recorded. Okay, that says clearly, my lords, if an application is made, it is incumbent upon the court to send him for an examination. And even without an application, if the court believes, my lord, and the submission, my lord, there was no documents appended for a medical. If there were documents, why would someone ask for a medical examination? They would have directly produced the documents. It is not.
It doesn't mean just because somebody is having some problem now, or say in 10 years back, that he cannot be cured.
No, exactly. My learned senior
So
friend
you
has
see, it
submitted.
doesn't, you see, because a person who is having some mental problem, he can be cured of this. That prove that he has a mental problem.
No, my learned friend submitted that along with the application, that unsigned application, there ought to have been some documents to show that he.
My submission, my lord, my
It's a-
submission.
it's a
Her submission.
She can submit anything she wants.
And your lordship, at the time of commission of the offense, he was not suffering from any legal insanity. That was not like put it on record. Nothing has been, no evidence to that effect.
Right. The learned APP substance. There being no evidence to show that the appellant was suffering from any unsoundness of mind at the time of commission of offense. The appellant cannot now pray for examination, medical examination regarding now to determine whether the appellant was of unsound mind at the relevant point of time. That's one thing you write in his. The counsel for the appellant submits that in terms of the judgment of
The Honorable Gujarat High Court.
in terms of the judgment of the division bench of the Gujarat High Court
In state of
in the
Gujarat,
case of
state of Gujarat versus Manju Ben, MANJUB.
in the state of Gujarat versus Manju Ben, DO, daughter of Kasturbai Nanji Bhai. If a plea of insanity is raised by an accused, it is the duty of the prosecution to subject the accused to a medical examination immediately. If such. If the same is not done, the proceedings, the criminal proceedings initiated against an accused would be violative of Article 21 of the Constitution of as his liberty, life or liberty would have been deprived without following the procedure established by. Correct?
Yes. And it also states, my lord, that the public prosecutor is not supposed to seek conviction by hook or crook. It states
We
that.
do on lordship is aware of.
It states in paragraph 28. I just read.
He also submits that.
No, I'm not submitting that.
Anything else? Okay, then
I'll be relying on
Prakash,
Kashmir.
in support of a submission that the appellant uh, 2023 in support of a submission that the onus of proving unsoundness of mind is on the accused. Yes, which para?
Lordship. I'm just quoted, madam. My paras are different from Manupatra. I'll be relying on two.
No.
Message.
Okay. Quoted line.
And that the crucial point of time at which unsoundness of mind should be established is the time when the crime was actually committed. Lies on the accused, she has relied the judgment of the Supreme Court in so and so reported in 2023, 5 SC 6/7. That's all. We have heard the learned counsel for the party. Hearing concluded, judgment reserved.
Very grateful for a patient hearing.
We are learning also. Yes, yes. In that state of Gujarat, you say criminal appeal 474/2019. Wait, envelope. Oh, single page. Oh. Okay, then just call out. I mean, they might not be here. POCSO matter.
POCSO matter.
What is your case? Difficult.
The petitioner was arrested on 19/11/2022, almost 3 years from now. Lordship, the case is still in appearance stage.
Hasn't the trial started?
My scan copy will be required, but I don't know what is.
Has trial started?
Yes, Lordship.
The trial has started.
Yes, Lordship is, it is an appearance state because he was arrested on 19/11/2022. From that day onwards, it is an
You
appearance.
see, Mr.
stage.
Koche,
Madam.
one thing, you come to page 74.
Till now, Lordship, no witness has been examined.
Para 44.
Yes, madam.
Para 45. This is the-
Yes,
What has happened is the co-accused is absconding.
yes, madam.
Now, because the co-accused was absconding,
Madam,
the trial has not started by the learned trial.
madam.
Now, this person's bail has been rejected 4 times.
Madam,
Now, this court had directed
madam.
the learned trial court to start the trial, even in the absence of the co-accused.
Madam,
You cannot, because that is allowed
madam,
in terms of section 350C
madam,
BNSS.
madam.
So find out whether the trial has started and why it has not started.
Madam, a report may be called from madam on the court below, madam. Present status of the case, madam.
What from the court below?
Because
And
madam,
what-
it is a certified matter, madam.
Okay.
So registry will call.
Right. Heard, Miss
Lordship M. Bhuya,
M. Bhuya appearing for the appellant, for the petitioner
petitioner, Lordship.
who prays for bail. Mr. R. Kaushik appears for the additional PP appears for the state. Next paragraph. Right. The petitioner's previous 4 bail petitions have been dismissed by this court. Good stuff. In the last order, dated 24/6/2025, passed in bill application 1371 of 2025. This court had directed the trial court to proceed with the trial of the case, even in the absence of the absconding co-accused, in terms of section 350, capital C BNSS. After taking steps for declaring the absconding co-accused as a proclaimed offender under section 84 BNSS. The registry to ask for a the registry to ask for a status report with regard to the stage of trial in the learned trial court. No, in the court of the which court?
Lordship Learned Special Judge, Kamrup Metro.
In the court of the learned special judge Kamrup Metro,
Special Judge NDPS.
NDPS, Kamrup Metro. In connection with
NDPS case.
NDPS case number 60 of 2023. Bracket corresponding to Guwahati GRPS case number 163/2020. List the matter on when? November.
That should be after vacation, Lordship, Diwali vacation.
It may not come, I don't.
It will not come within
The first week of November, Lordship,
the first week.
7th.
I will not be here. 14th also I might not be here. Wait, just let me see. 14th, 15th. 14th I'll be here. 14th I'll be. 14th I'll be here. Justice Jameel's daughter is getting married on 11th.
Oh.
So if I don't go, do that.
My lord, this is an application filed by the state, my lord. This is about that, my lord.
So
question-
do we issue notice or what?
Only notice, my lord. That's it. My lord, we are only before lordship, we are complying. We have taken all possible steps, my lord, to comply with the order. Now we have formulated a SOP. We have given out a notice published in the newspaper. Everybody, not only this writ petitioners, my lord, the last page, my lord. So, my lord, that is why it's a Herculean task, my lord, very
I know.
elaborate. So,
How
it
many
takes,
crores?
yeah, my lord, it takes some time. So, my lord, only this application is that we are seeking 1 month extra so that we don't get.
You are asking for 3 months extra, not 1 month.
3 months, I'm sorry, 3 months, my lord. So, my lord,
So supposing we allow 3 months, how is the end of the matter? Notice is required or not?
not required, my lord. If my lord allows 3 months, it is done. Suppose we will be finishing it up. Today, when I have spoken to the commissioner secretary, he said maybe in 1 month time only, almost it will be done. So,
Election, no?
so my lord, this 3 months and or else notice, my lord, and let it come after 8 weeks, my lord. But by then also it will be done, man. Because the bigger part we have already taken care of, complying on the order. Now the writ petitioners, all this, and other than the writ petitioners, they are coming with all the documents to the government, my lord. So we'll have to just pass an speaking order, well, considering their cases. That is the thing. That is taking time.
3 months time. I
3
think it should be allowed because already half a month already gone. But then they'll say that no notice issued.
No, my lord will issue notice, my lord, and let it come after 8 weeks. By then, my lord, I think I will also pressurize the government, my lord. Let them finish it. It is not that, my lord, we are not complying. Almost 80% we have complied, my lord.
80% complied, okay.
Complied.
A few have, how many writ petitions are there? One.
Here, my lord, the main case, my lord,
No, out here in this one. In this, there are only two.
two, my lord.
Correct. Heard Mr. R. that learned counsel for the state of Assam, who praised for 3 months extension to comply with the order dated 3/4/25, with effect from 3/10/2025. But you won't take steps anyway.
My lord, I will take step.
Issue notice returnable in 4 weeks. Applicant to take steps for service of notice upon the respondent by registered post within
Oh,
within 2 days,
My lord,
within 4 days,
4 days. There is vacation in between again, my lord,
or within a week.
within a week.
This is the matter after 4 weeks.
Deeply obliged, my lord.
How should we allow it?
My lord can allow it also, my lord. There is
No point.
no point, my lord.
Okay, well, instead of just say, on considering. Now, before that, right, Mr. R. submits that. That due to due to a large number of cases that have been disposed of pertaining to the same issue, and given the short amount of time given to the respondent government, to the applicant government, the 3 months time, the 3 months extension may be granted for compliance of the order. On considering the above submission made by Mr. Azad, this court is of the view that 3 months extension should be granted to the applicant. According to the applicant is granted 3 months extension for compliance with complying with the order dated 3/4/2025, passed in WPC number 342 of 2025 and 780 of 2025. Correct?
Well,
What is this? It's, wait a minute. Acha, this is that all that.
that case, my lord, compassionate appointment.
No, I know. But
My lord,
we have put in only. Okay.
My lord, there are 67 writ petitions, my lord.
We have completed 80%.
Yes, means, my lord, we have made an SOP how to comply the order. Then we have taken out a notice through paper publication to all the writ petitioners that you submit your documents so that we can consider your cases. So that has gone out. Now these are coming, my lord. So once this comes in, we have given a last date also, 15/9, last page of the notice, my lord, last page of this writ petition. So this will take some time, my lord, only to pass a speaking order, because we have to consider then pass speaking order.
So you have asked only for 342 of 2025. Your prayer is only for one writ petition.
My lord, prayer is actually for connected cases also, my lord.
Other linked cases.
Link cases, my lord. Link cases, my lord. With this, all the cases got clubbed.
Is it? What have I said? Read from the beginning. Passed in WPC 342 of 2025 and other linked cases. Then the compliance of the order with effect from 3/10/2020. Next para. The 25 and other linked cases. First up, accordingly, 3 months extension is granted, to the applicant for compliance with the order dated 3/4/2025 and other linked cases with effect from 3/10/2025. I is accordingly disposed. Yes.
Lordship, as per Lordship direction, affidavit has been filed, Lordship.
We are ready. So what is your case? What is to be done?
No, as per rule clause 24, your lordship, it is to be signed by a dispute redressal discourse.
Huh?
Clause 24.
So where is the termination of the contract? The order?
Lordship, in the page 133, Lordship, initially he was given a notice to complete his work. Page 133, Lordship.
Yes.
Thereafter, on again next page, Lordship, 134, he was again requested to complete the work. Then on Lordship, page 135, Lordship will see with reference to the giving reference of the earlier with reference to the during my visit at so and so, along with so and so, and inside it is seen that you have not taken any initiative to expedite the work, and it is great displeasure that in spite of repeated verbal as well as written persuasion, you have failed to improve your progress as per terms. Therefore, you are hereby once again requested to improve your progress within 7 days time from the receipt of this letter without fail. The notice we treated as final notice. Thereafter, Lordship, again, since there was no progress in the work, Lordship, in page 136, the final termination letter was given. And subsequent to this letter, Lordship, dated 23/9/2016, Lordship, page 137, he withdrew from the contract stating that due to his ill health, and he said that it may be given to some other agency for completing the work. And accordingly, Lordship, other agency through tender process, they were given the work and they have.
Who is that other agency? Where is that?
That Lordship name is not there, but I have given a statement, Lordship.
Where? In the affidavit?
Yes, Lordship. Page 129, Lordship. Second paragraph, pursuant thereto, the petition submitted a work program for completion and monitoring of the work, but such assurance also went down the drain and there was no response of the petitioner. As a result, in the
Okay, anyway. So what is to be done now? What are you praying for out there?
Lordship, clause 24.
Of the GCC.
Yes, lordship.
So you want to avail this? You want to avail the GCC? So you withdraw with avail, by saying that you want to avail this. Huh?
In this line, Lordship, close 24 members.
Okay. So let him, if he wants to go, let him avail 24.
Yes, sir.
Heard, Mr.
R.H. Undul.
R.A. Chowdhury, learned counsel for the petition. Also heard Mr.
B Chaudhary, Lordship.
B. Chowdhury for the
PWD, Lordship.
PW. The petitioner's case is that his contract was terminated by the respondent. This says, this order dated 6/5/25. Para 1, para 2. Oh. And before that, yeah, para 1, para. Then order dated 29/4/25, second para. Okay. Next. On a perusal of the documents on record, it is seen that the petitioner was allotted the construction work of road from Rangadaria to Digali Pathar, page 128, para 4. Huh? Then you take down the whole thing, okay? So it's starting from Rangadaria, you carry on. Then para 5, page 130. Okay. Next. As can be seen from the above facts and the documents on record, the contract work has been terminated. The petitioner's contract work has been terminated due to the petitioner not being able to complete his contract work despite various letters issued to him to complete the contract. Also, the petitioner is not willing to continue with the contract. Where is this clause 24? Page
This is a page number 80.
80. Yes, sir. As the petitioner's prayer in the present writ petition is for a direction for payment of money which can be agitated under which can be agitated under clause 24 and 25 of the general clauses of contract. This court is of the view that the petitioner would have to avail of the alternative, efficacious alternative remedy available for his claim for payment of bills, if any. In as much as the same would relate to questions of fact. Accordingly, this court is of the view that the present writ petition is not maintained. The writ petition is accordingly dismissed. However, liberty is given to the petitioner to ventilate his grievance in terms of clause 24 and 25 of the general clause of contract. If certain.
Obliged.
So both, na?
Same.
Same. Out here, what is there?
Same.
Same lordship, only one affidavit I have, they are the,
Both.
report. it will cover.
Okay, say appear in both the reports. It's both by a common judgment order. Same contract work or different contract work?
Contract work is different, but the reasons are,
Huh?
reasons are same.
One is package number AS 119-290.
Page. But what about the notices? Same.
Same.
Notices for both the same.
Same.
For same.
Same.
No, let me see the notices whether same. You are saying same, might not be same. Construction of Rangade Dale L221. No, this is different.
She may find it at annexure 5, page number 16.
Next year 5,
Page number 16. I have
30.
160. And annexure 6 is the physical progress.
16. 16 is no withdrawal of
Next page, Your Lordship.
huh?
Next page, annexure 6, page number 16. With reference to it is going to inform you that in spite of repeated requests and instructions, you fail to achieve proportionate progress of.
That is page 17.
Yes, Lordship, page 17. Annexure 6.
You said 16.
A final notice was issued to you on 28/9/2016 to resume the work within 7 days.
Okay, similar, but it will be changed. Those things will not be there. That paragraph 4 and 5 will not be there. You just make it, we'll see. I've got a meeting. That's all, no. So these are two different work,
Works are different.
but the notices that you have not given notice for in the other case.
Our lordship directed in that case and that.
Only. Anyway, we won't mention that paragraph 4 and 5 in the other. We'll make separate.